Now, kindly indicate the male candidates, my lord.
Preference given
Well.
in favor of female candidates
In staff nurse, my lord.
Grade 2.
Recruitment of staff nurse, grade 2.
2.
That is at my lord. It will be clear, my lord. 202. If you lordship, see 202. Clause 4, staff nurse, grade 2.
clause 4 of
202, my lord.
202, my lord. Page 202, clause 4. Post has been mentioned. Staff nurse, grade 2.
is a method of recruitment. Just
Post, my lord.
Post, my lord.
This is the post.
Roman 1.
Name of the post.
staff nurse grade 2
My-
in recruitment of staff কি বলছিলাম in recruitment of staff nurse grade 2. Stop. Next paragraph. Next, state respondents are represented by learned advocates. Stop. Considering the issue involved in this writ petition and the nature of challenge thrown to a particular provision is to a particular provision as amended vide Gazette notification dated 27th April 2018. There is no scope for passing an interim order. Stop. Issue, no, stop. Issue needs to be decided after calling for affidavits. Next paragraph, let affidavit in opposition to this writ petition be filed by 2 weeks after ensuing Christmas vacation. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter.
1 week.
By 1 week thereafter. Next paragraph. Petitioners shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits.
When I'm praying for leave to file one supplementary affidavit in the annexure portion, I read it wrong. That is, but P1, P2 I have referred, but annexure I mentioned A.
The over the supplementary affidavit filed on behalf of the petitioners is taken on
The
board.
copy has been served up in the state. I'm grateful.
In one matter, I have requested learned advocate general to appear.
Yes, my lord. Yes, my lord.
Yeah,
No.
because there are no benches under West Bengal Administrative Tribunal. Now the litigants are coming directly before this court, which prima facie court has expressed view that if tribunal is not available in consideration of L. Chandrakumar, litigants or the petitioners are required to approach the honorable division bench, not before the single bench of High Court. Now, the present judgment of Rogers judgment is being relied upon as a 5-bench judgment. So, tell Mr. Advocate General to appear on a particular date where
Probably it will be taken
after
up on
vacation. After
Fine.
vacation.
Okay.
Probably on 6th.
6th.
I'm grateful to know.
If in the meantime appointments are made, issue will be diluted.
Yes, ma'am.
Tribunal. Otherwise, court has to consider.
Considering that issue also, if there is only one member and the party will, my lord, give consent, they can move the.
So now they are submitting, there is no members. Yes.
Item number 3.
For the respondents,
For
madam.
the petitioner, as per your lordship's direction, I have served to the respondent number 6 an affidavit of service. They have received.
Yes, what is the present position?
My lord, two, my lord, verification is required. One is from, my lord.
Have you obtained any?
Yes, my lord. Yes, my lord. One is from the Director Central Fingerprint Bureau. That is response number 6.
That you have obtained.
That I have obtained. Then we have sent to the, my lord, response number 4 before, my lord, the Central Forensic, my lord, Laboratory for, my lord, verification of the, my lord, fingerprints, my lord. So, my lord, if you lordship, my lord, these are, my lord, I can show to your lordship the instruction. Here, my lord, on 22nd, on my lord, 2nd February, 2nd December 2025, my lord, we have received the instructions from Director of, my lord, fingerprint. Then, my lord, 3rd, we have sent before the response number 4. That is, my lord, awaiting, my lord. After, my lord, getting, my lord, 2 reports, we can, my lord.
When you will be able to produce the report from Central Fingerprints Bureau you have
Received.
Now you have sent to the
The Central Forensic Laboratory.
Forensic Laboratory.
Kindly fix, my lord, time limit, my lord, judicial order may kindly be passed, my lord, it will be, my lord, easier for us.
No, why? In all matters, the judicial order is required to be passed. You obtain order or obtain report from CFSL.
Very well, my lord.
Central Forensic Science Laboratory you have sent.
Yes, my lord. Newtown. We have sent. On 3rd December. 2nd December we have received, and on the next day we have sent.
What is the report so far? Fingerprint.
My lord, original report has been sent, so report has not been sent to me, my lord. Only, my lord, instructions I have received that they have received the report from, my lord, the Central Fingerprint and then sent to the, my lord, Forensic Laboratory.
Forensic Laboratory is party.
Yes, my lord. Yes, my lord. Response number 4, my lord.
So you are representing Forensic Laboratory.
Yes, my lord. My lord.
Response number 4.
4, my lord.
Issue. Mr. Ghosh, learned advocate representing Union of India on instruction submits that pursuant to the order dated 19th November 2025, Central Directorate, Central Fingerprint Bureau, National Crime Record Bureau, New Delhi, sent the report on 3rd.
On 2nd, my lord. 2nd February.
December 2024 to BSF.
To, my lord. Yes, my lord.
To Border Security Force, and said report was forwarded to CFSL.
My lord.
And the report and the said report, and on receipt of said report, same was forwarded to Central Forensic Laboratory, Kolkata.
On 3rd December.
On 3rd December 2025 for obtaining further report.
Obtaining for, my lord, handwriting and signature verification, my lord.
For obtaining
handwriting and signature verification.
For obtaining report after verification of handwriting and signature of the petitioner.
My lord.
So, next paragraph. Director, Central Forensic Laboratory, Kolkata, being response number 4, is directed to forward the report by fortnight from the date of communication of this order to border security force, as appointment of the petitioner for the post of constable GD depends upon such report, and petitioner is one of the waitlisted
No, withheld list.
with one of the candidates whose name is a candidate whose name is featuring in the list of withheld candidates. Next paragraph, learned advocate representing the petitioner is directed to communicate this order to the respondent number 4 by 7 days from date. Stop. Next paragraph, list the matter under the same heading for further consideration on January 2026.
Malad,
Get
get
the
lost.
Item number 4.
for the petition in this matter.
Yes, what is your instruction? You are referring for the state
Filing
respondent.
report, Malad.
No, mayor filing report will not do. ফেরত দাও. Now it is petitioner has been terminated from service on 7 by dismissal order dated 17th October 2025. Now the basis of termination is involvement of the petitioner in a criminal case, that is Manik Chowk PS case number 443 of 2016, dated 19th October 2016. Petitioner submits that the authorities proceeded on the premise since one Imam Haq alias Imam Hussain was involved in the said criminal case, was implicated in the said criminal case, but said Imam Haq or Imam Hussain is not the petitioner. So what is the report to that extent? Tell me.
These are same and identical person, Malad. Son of Sheikh Duggi, what I could recollect this, Malad. Sheikh Duggi, Malad. His actual name is, Malad, Tajimul Haq. These are same and identical person, Malad.
Who are same identical person?
Milord, this Imam Hussain, Milord, son of Sheikh Duggi, as is in the FIR, Milord, and Imam Hussain, son of Tajimul Sheikh. Milord, these are same and identical person.
Yes, Mr. Lahiri, you demonstrated on last occasion that petitioner is not on what, based on which documents?
Yes, my lord. Kindly, my lord, first of all, I will show that page 32, this is the complaint. Complaint copy. Possibly Lordship had marked also. Kindly see Imam Hussain, Pita Sheikh.
At the middle, Imam Hussain.
Imam Hussain Sheikh Duggi.
Pita Sheikh Duggi.
I am Muhammad Imam Haq that I have stated in page 21 in my application form. Page 21, son of Muhammad Tajimul Haq. Now, my lord.
Just a minute, page 21.
Page 21. Kindly see. Name Muhammad Imam Haq. Father's name Muhammad Tajimul Haq. He is the petitioner before your lordship.
My lord, the complainant in this,
May I just a minute.
My lord, before adjudicating, my lord, may I be heard, my lord?
Please wait.
Make my submission.
I am waiting, my lord.
Yes, Imam Hussain Mohammad Tajimul Haq is the petitioner.
Muhammad Imam Haq is the petitioner, son of Muhammad Tajimul Haq. Now,
Yes, Imam Haq is the petitioner. His father's name is Tajimul Haq.
Tajimul Haq. Now, my lord, kindly complaint copy Imam Hussain, son of
Duggi.
Now, my lord, in the FIR also, next page, same. Kindly, Lordship, see the middle portion, right hand side, Imam Hussain, son of Sheikh Duggi. Next, my lord, kindly.
Page 37.
Page 37. No, page 37 is their report, which I'm disputing. My lord, kindly come to page 44 once. Page 44, the Manikchok PS Malda gives a report.
When you were appointed?
I was appointed
22, 2020.
2023. 2023. I have appointment letter page 17. 28th of August 2020.
So it's a police verification report prior to appointment.
Yes, prior to appointment.
After.
Now, my lord, kindly see the court's record. In the bail order also, before the learned trial court, the name is Imam Hussain at page 43.
Page
43. Well, that person had obtained bail in that proceeding. Kindly see the last paragraph. Imam Hussain.
Yes, Imam Hussain.
Imam Hussain. Now, my lord, we obtained reports from the court itself, page 45 onwards. Kindly see. This is the official record we obtained from the court, page 45. Whether, question number 1, whether Muhammad Imam Haq, son of Muhammad Tajimul Haq, resident of village such and such, post such and such, Manikchok, PS Manikchok, district Malda, is FIR named in connection with above referred case being such and such. Question at right hand side, extreme right hand side, serial number no. Serial number 1, no. Question number 2, whether Muhammad Imam Haq, son of Muhammad Tajimul Haq, such and such, is charge sheeted.
Now the point is,
Page 40.
there was a police verification prior to appointment of the petitioner. Now in the police verification report, which is
44. Page 44.
which is at page 44. Come to page 44. You don't have the brief.
My lord, my clerk is not here.
No. The actual matters wholly based on facts and without brief you are appearing.
Hmm.
With a report from the police authority, please see the report. If this is the assistance the court gets, then it is difficult to adjudicate the issues, especially this kind, the issue, the nature of issue involved in this writ petition. First, state respondents were directed to appear. There's a notice, direction to serve notice. In spite of that, nobody appeared. Matter was adjourned, and today, state government, state advocate is appearing without brief. Come to page 44.
Hmm.
Already there is a police verification because it's a case of 2016. Criminal case is of 2016.
2016.
You will get the criminal case. I have recorded in my order. PS case number 443-216,
Manikchok.
2016, dated 19th October 2016.
Hmm.
Is Manikchok PS case number. Now come to page 44.
My lord.
Manikchok PS Malda, what they are saying, please read it.
Further verification, it is certified that no adverse record could be found. Mohammed Imam Haq, son of Mohammed Tajimul Haq.
Now, come to page 21. It is an enrollment roll and enrollment form of Border Security Force BSF. Page 21.
21.
Serial number 1, name of the petitioner Mohammed Imam Haq,
My lord.
and father's name Tajimul Haq.
Tajimul Haq.
Come to the complaint.
Imam Hussain.
It is a complaint dated 9th October 2016, based on which this criminal case was initiated. 19th October 2016.
My lord.
Now it is complaint at the middle. Find out the name of a person, Imam Hussain,
Imam Hussain.
Pita
Sheikh Duggi.
Sheikh Duggi. Turns to next page. Turns on to next page. Page 33. FIR dated 9th October 2016 against clause 7, details of known, suspected, unknown, accused with full particulars. Then 8 reasons for under clause 7 it is stated Imam Hussain 20 son of Duggi, Sheikh Duggi. So how it was subsequently reported at page 37 by the Superintendent of Police Malda, DIB Malda, that petitioner is the same person against whom he is one of the accused in that criminal case which was initiated in 2016.
My lord, the complainant has addressed a letter to the DGBSF stating that this person is the same and identical person.
Complainant?
The complainant in the Manikchok PS, my lord. That complainant, my lord, had addressed a letter to the DGBSF stating that these two are same and identical person.
And based on which petitioner has been terminated. Now, I want a specific report with regard to identity of this identity of the petitioner as well as Imam Hussain, son of Duggi, who is involved in the criminal case, who is implicated in the criminal case, and whether the petitioner and Imam Hussain is same and identical person. That is the crux of the issue.
Kindly come to page 37 for once. Father's name is not mentioned. Page 37.
For which state's presence court felt is necessary.
Kindly goes to the report once. My lord, here it is mentioned that they have the DIB, my lord, had examined few witnesses, my lord, and they stated that this is the same person, my lord.
Then why this police verification report was issued? Page 44. Come to page 44. No.
Appointment.
It is after the initiation of criminal case in 2023 by the same police station, Manikchok police station, officer ASI Manikchok police station.
That I have to take instruction, my lord.
Same police station, it's subject to further verification. It is certified that instantly no advance record could be found against Muhammad Imam Haq, son of Muhammad Tajimul Haq. And nowhere it is found that the name of the father is Sheikh Duggi.
My lord, the witnesses state otherwise, my lord. The local witnesses, my lord, they state otherwise, my lord. My lord, this person is locally known as Sheikh Duggi. And that's one of the reasons, my lord, this complainant has named the father name as Sheikh Duggi.
Based on hearsay, I will be terminated.
Yes, so do you have a copy of this report so that you can place the relevant part of this report?
My lord. My lord.
No, another copy you have?
Yes, my lord.
Yes, give me the report.
The last para, my lord. Examination of witnesses.
Who examined witnesses?
My lord, the DIB, the officer in charge of the DIB, my lord. DIB Malda. Even the complainant has identified, my lord, what the DIB is stating.
Complainant may have some vested interest.
Vested interest against the person.
Just a minute.
Sir, ये पेज नंबर एखाने सोई पेज नंबर 31 এই যে চিঠিটা
সেম মানিকচক পিএস আবার একটা রিপোর্ট দিয়েছে মানিকচক পিএস
another report of
another report.
Yes. We don't know how that ASA is given, but that same money chop PS is given. That may also be taken into consideration. That was also taken into consideration. This is only kindly consider that, but some other report same marks.
Mother of the said petitioner, own name আছে তাজিমুল, wife of তাজিমুল হক.
Who is the investigating officer in the in the said case? But the case is pending. What is the present status of this case?
My lord, the next date is
Kindly
fixed
see
for
the police's.
Because he will say that he doesn't know.
They-
He is not implicated in that criminal case.
But
What is the
subsequent
present
report of-
status of the criminal case of 2016?
my lord, fixed for consideration of charge on 17th of February.
Consideration of charge. So
Consideration.
therefore, the petitioner, if the petitioner is the same person
Yeah.
who is implicated in the criminal case,
Yeah.
he must have appeared before the
Appeared,
investigating officer.
My lord.
So therefore, obtain a report from investigating.
Well, there is another report. Well, there is
Lord,
another
subsequent
Kindly
He
see
may obtain a report from investigating officer.
Yes, there
He
is a
knows
report.
everything.
My lord, that must.
There is a
It is
report.
the end of the matter.
Subsequent report from the same Manikchok case, my lord.
Subsequent police's subsequent report.
It is not required at all.
So Manikchok PS's report, he has submitted.
It's
right?
not required at all, because in the criminal case, you are saying that I am not
The same
The
person.
same person.
same
It's
person
a fresh
who
report.
is implicated in the criminal case of 2016. Now, in support of such statements, certain documents are relied upon. Now, the thing is this: only question is whether you are implicated in the criminal case or not.
And who obtained bail also.
Already matter is fixed before the trial court for consideration of charge. Charge sheet has already been filed under 173
Well,
of CRPC.
well.
Now, because it is 2016 proceeding. Now, if that be so, then the investigating officer is the best person to clarify
Yes,
whether petitioner is the same and identical person or not.
Only one.
Who is the investigating officer?
Only one thing, my lord. My
Raj.
Lanet has submitted
Yeah,
another
correct.
report the IC has said. Kindly see once one paragraph. Another report has been
I
submitted.
will not see anything.
Kindly
after
see
this.
Kindly see the
Let the investigation come.
My lord, may I submit my
no
lord?
voter entry was found. Kindly see for once, my may I request once, my lord. It's a factual matter. This next.
Yes, Miss Sinha. Who is the investigating officer? So far, the criminal case of 2016 is concerned.
Who is the investigator?
Rajkumar Mandal.
কোথায়?
And my lord, the complaint said mistakenly name was given. Kindly
Yes,
see page 2. Mistakenly.
My lord,
And-
I am told it's Mr. Rajkumar Mandal.
what is his designation?
Yes, sir.
বলো।
Yes, sir. Yes, sir. Sub Inspector. Sub Inspector.
Sub Inspector of that police station, Manik Chowk, PS Malda.
My lord, may I submit, my lord?
Why you are
I require
coming
to be,
in the way?
I require to
Let
be
me-
heard, my lord, because I am
At
the.
this stage, it is not required.
My lord, it
Whatever
is
you have
required,
done,
my lord.
whatever you have done, you have already terminated the petitioner.
But before, in this
Let-
court, my lord, I have come, I am answering, responding.
I will consider
need to be
it.
heard, my lord.
If it is found that the petitioner
My
and
only
and the-
contention is, my lord, this is an appealable order, my lord.
please hear this court. If it is found that the petitioner is the same person,
My
It is
my
an
contention
appealable
is
order.
that this court should not go into that matter,
should not.
my lord.
No.
That
If
is
there
my
is a- if
contention.
there is a provision of appeal, then normally court do not exercise
That
discretion
is what.
to
Exactly.
entertain appeal. That does not mean
No, no,
that the writ court cannot entertain
no,
the
no,
appeal.
my lord
Entertain
can.
the writ
My
petition
lord can.
since
My
there is an appeal provision.
my lord can. My lord can, but I need to be heard.
Yes.
I needed to be heard. my
Very
lord.
basis is whether the person is implicated in the criminal case. What your appellate authority will do at this stage? Your very basis is this, that the person was implicated in criminal case. Whether the person implicated in criminal case is the same and identical person as the petitioner, who is an employee or who is working under BSF,
My
that is the whole issue. If that is proved, then everything goes.
Then
If
nothing
that-
remains to be
Yes.
decided by the
So,
appellate
so
court.
therefore, don't take this point, Mr. Counsel, that there is an appeal provision that the writ court cannot exercise its discretion.
Can, my lord.
Normally, we
Doesn't.
do not exercise such discretion.
Yes, my lord. That is what my contention was.
Yes, but writ petition is maintainable.
My lord has that power. Inherent power does my lord.
They say the voter list is different.
Yes,
They say voter list name is different.
nothing is required. I want a report from the investigating officer.
My lord, since
Why you are going here and there now,
there is a
Mr. Lahiri?
reason, because there is a dichotomy between their
Yes, yes.
in one report.
Yes, yes, Miss Sinha, who is the investigating officer?
Rajkumar
Rajkumar Mondol. Where from you are getting this?
from the FIR, my lord.
There's no change in this.
So in the meantime, there may be a change. 2016.
Yes.
Obtain instruction that who is the investigating officer.
Based on record, they cannot open.
I want a straight report from the investigating officer, because this petitioner, if petitioner is implicated in the criminal case, he must have appeared before the investigating officer.
Whether he can override DIG's order.
Yes.
DIG
Court
has
can.
asked-
Court-
Court can
court
absolutely. Whether the investigating officer can
Yes.
override
Yes.
DIG.
Are you aware of, are you in a position to apprise this court that who is the investigating officer?
Lordship, may I come back with instructions? Proper instructions, my lord.
Only thing court wants that who is the investigating officer.
Lordship, may I come back with instructions?
Issue.
They have already given it on writing, my lord. So I do not know whether there will be any difference because the higher
Oh,
authority.
very well. Not today. Come back tomorrow.
My lord,
Obtain
kindly ask some order, my lord. I am standing
obtain
here for 3
instruction.
days. Nothing.
Obtain instruction that who is the investigating officer. Miss Sinha, obtain instruction that who is the investigating officer. Come tomorrow.
Lordship,
My lord, tomorrow I will not be available, my lord. I will be there in court.
Your presence is not required at
It
this
is
stage.
required, my lord, because I am the answering respondent, my lord.
If ultimately if it is found that they are same and identical person, then your order will remain.
Apart from that,
If it is-
I may have
please-
some other contest.
Please hear this quote. If ultimately it is found that they are not same and identical person, then question would arise
Yes.
whether your termination order will survive or not.
My lord, I understand, my lord.
In that, at that juncture, your presence will be required.
My lord, I understand, my lord. State is accommodated, but I will not be accommodated. That is not fair.
Okay, your accommodation is, your instruction is not required. When your instruction will be required,
I am the
you
answering
are
respondent.
always accommodated. Please don't quarrel with the court.
I am standing.
Since
here for
no order
3
is being
days, my
passed
lord.
today,
They are
which will
answering.
not inure to your benefit,
এইখানে?
My lord, at the
then
end
I
of
have to
the day-
tell the additional solicitor general
Yes.
appropriately. Yes. Please take your seat.
Report has been sent by SP.
Who is the investigating officer? Who is the investigating officer? I have seen this report.
Have you? Lordship.
Don't waste court's time. Who is the investigating officer? Are you in a position to apprise this court?
Change also.
Tomorrow, inform this court that who is the investigating officer.
May I come back with instruction?
Yes. Matter is heard in presence of the learned advocates representing the parties. Stop. A report dated 11 December 2025, prepared by Superintendent of Police DIB Malda, is filed in court today and same is taken on. Next paragraph.
Yes.
Issue, next paragraph. Issue is whether Muhammad Imam Haq, mananta EMAMHOQUE, MD তার আগে, son of MD Tajimul Haq, TAJIMULHOQUE, is Muhammad Imam Haq, son of so and so, and Imam Hussain,
IMAM.
son of Sheikh Duggi.
Check.
Sheikh Duggi.
Imam spelling is different. IMAM, not
IMAM.
IMAM.
IMAM, son of Sheikh Duggi, are same and identical person, is same and identical person, or they are different, is same and identical person or not. Stop. Petitioner in the present writ petition is MD Imam Haq, who has been terminated from service as it is found by the concerned authority of BSF that he is implicated in a criminal proceeding, being PS case number 443/2016 dated 19th October 2016. Manikchok PS case code. Stop. Next paragraph. Learned advocate representing the petitioners, learned advocate representing the state respondents submits that the criminal case to be considered by the court, the criminal case is to be considered by the court on 17th. What is the date? Next date fixed?
17th of
কবে ডেটটা বলে দাও।
17th of February.
17th of February. Where it is stated?
27th February 2026.
Where it is stated in the report? Second page.
Yes.
Which paragraph?
First paragraph. Continuing that. First paragraph.
ওইটা দেখাচ্ছে ছোটটা, বড় বড় রিপোর্টটা।
Report.
On 27th February 2025.
2026.
On 2026. Yes, it should be 20. On 27th February 2026. Stop. Next paragraph. This court finds that investigating officer in Manikchok PS case number 443/2016 dated 19th October 2016 is in a position to apprise this court whether aforesaid two persons is same or identical person or not. So, learned advocate representing Ms. Sinha, learned advocate representing state respondents, has paid for accommodation to apprise this court that apprise this court about the investigating officer in connection with the aforesaid criminal case. Stop. Hearing of this matter stands adjourned till Monday next, 22nd December 2025, for taking further instruction. Stop. Next paragraph. Client advocate for the state respondent shall also be at leave to obtain a report from the investigating officer before the next date of hearing.
I'll be relying upon their documents also. They have given all the Aadhaar card, voter card, everything. I'll be relying on that also. Grateful to Lord. Much obliged.
Item number 5.
Beg to appear on behalf of the petitioner, my lord.
Yes,
Pass over your lordship. My senior is engaged in courtroom number 12.
My lord,
who is your senior?
June Kumar Mukherjee, Roy Mukherjee.
on the last occasion also, my lord, they had sought for an accommodation. There is some overwhelming urgency, my lord.
Whether you will oppose?
My lord, what I was humbly, my lord, submitting, my lord, may kindly consider my my limited prayer, my lord. But just here's the
So
fact.
pass over, let Rai Mukherjee
My
come.
lord, may kindly, my lord, hear the fact, my lord, once, my lord.
I will hear you, but
Then,
not
Madam,
now
kindly, Madam-
since the accommodation is paid
My lord,
for.
may kindly, my lord, keep it on Monday, my lord. So why I'll tell you, lordship, my lord.
Several matters
No,
are
this matter, my lord, is so urgent, but my junior was
tomorrow, today it will be taken up.
Yes, lordship, 10 minutes accommodation will do.
Third pass over.
Then, my lord, may kindly take it up at 2, my lord.
Original side
I
matters
have
are
a
there.
matter fixed at 1 o'clock.
At 2 original side matters. If you are not available, then you will be accommodated after original side matters. It will be taken up. Let me see.
But in that event, my lord, may it be taken up on Friday.
No, 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 no.
আরে ভাই করে দাও না ভাই আমার প্রবলেম আছে
Yes, please call the next matter. Pass over. If you are engaged in other court, I will accommodate you.
Item number 6.
And for the respondent.
And for the respondent, my lord, as per your
The last occasion, your lordship directed to file the affidavit by.
And filing
I have
short
not
affidavit?
received any copy. My lord, the relating to the recruitment of the CISF driver, just
it.
now he is handing over. My lord, the notification says
Oh, that matter.
yes, my lord. This is the
Yes,
my lord,
affidavit.
this is the trade test
Affidavit.
I have given, submitted.
notification with regard to the trade test.
In which paragraph you have stated?
Regarding his certificate.
Yes. The regarding disclosing the reasons
Hmm.
for declaring that petitioner is not qualified in the test.
Annexure R4, page 9, and here I'm.
No, where you have made
Yes,
the
yes,
statements.
Paragraph 8. Paragraph 7 and 8 both can take.
7, just a minute. In page 9, where
Yes,
it is
page 9.
page 9, where it is stated that without wearing seat belt, without fastening seat belt, petitioner started driving.
Yeah, it is stated that I have been told about the grounds
Yes,
for my
that is-
rejection. And thereafter, he put another signature. You see, candidates who have left the ground, that is matter. So he has put his signature that he has been told. Has been told about this.
Yes.
That notification I have handed over to your lordship. Kindly have a look at trade test. There is a specific.
Page number. Page number 10.
Well, first of all, I want to use an exception to this affidavit because there are some allegation as per the law. It is stage of examination.
Yes, trade test.
First driving of LMV, light motor vehicles, 50 marks. Pass marks is there. Then heavy motor vehicles, marks is 50. Pass marks is there. And then the knowledge about the car, particular vehicles, that is also marks. Where is the, may I put this question to myself?
How does it help you?
Yes,
Because you drove the car without wearing seat belt.
yes,
That is impermissible in terms of the relevant provisions of the Motor Vehicles Act.
Motor Vehicles Act. I want to.
So how this will help
I
you?
want to
Clause
use
11.5 will help you.
that is the violation of traffic. Here, no traffic.
Whenever
is
you
there.
drive a car, you must wear seat belt.
I
at
have
the beginning.
never been allowed to drive the car. That is
Where
my
you have
sole
stated,
allegation.
where you have stated in the
Yes,
writ
I
petition.
have, specifically, I have made this allegation. I just put the start key.
Yes.
Paragraph 7. That at the time of driving test, when your petitioner just on the key for starting the vehicle by pressing key of the vehicle and shift the rear gear of the vehicle, the respondent authority examiner asked your petitioner to get down from the vehicle. Specific allegation.
Yes, rightly said, because you started the vehicle.
But there is a time. I should not.
Before starting, there is a specific statement. Before starting, you need to wear you need to fasten your seat belt.
No, nowhere in the notification as well there is.
What notification?
Notification for the employment.
For that, no notification is required.
Yes, of course,
We regularly
because
tell our drivers
motor
wear the seat belt and then start the ignition.
No, my lord. My lord, I'm your order is subject to the correction of your lordships. If I start a car in my house, there is no requirement for my lord.
No, you are not driving the car in your house ground. It was a trade. It was a
That's
driving
why
test.
I want to,
So it was,
make an exception of this.
You are not
affidavit
driving your
filed
car.
in the file.
You are not driving your car in the courtyard of your house.
All right,
It was,
but
it was a driving test.
yeah.
So therefore, you are required to follow the procedure.
Yes, if I complete the test and they said that you are not wired the seatbelt, then I can understand. But here I just put the key and start. They get down from the car and rejected my candidature on that ground. I have not wired the seatbelt.
It is
It
stated.
is the-
It is stated in paragraph 7.
Paragraph.
Accordingly, the petitioner started driving in reverse, but the said a motor vehicle inspector stopped the vehicle after reaching certain point as shown in map and asked the petitioner to get down from the vehicle.
Yes,
Because you are not
that is why
wearing
the last
seatbelt.
occasion they have
Shall I
produced
give
the
the
videograph that has
videograph?
not been
Shall I get the
produced.
video where he was starting and he was driving?
That is my instruction
So
of
why-
my client.
No.
I cannot improve that. I only can
You
that
cannot-
make an exception to this report because it is
That will not improve the
allegation is
position.
there, and I have violated
Only,
the Motor
this
Vehicles
is-
Act.
This is only to place on record the reasons relating to your failure in driving test.
Yes,
Nothing else.
That is
Therefore,
why
there is no question of any exception.
That is why I allege that this impugned order is non-speaking order. Here nothing has been mentioned. How I get the number, how much I get the number in the driving test, that has not been specified. This is a non-speaking order without assigning any reason, only driving non-qualified in the driving test. If I have not wired the seat belt and start the car and complete the test, then if they can reject it my candidature on that ground, stating that you have not wired the seat belt and drove the car.
Yes, sir.
But that has not been done, my lord. That is I want to.
It is the post of driver in BSF.
Yes, my lord. That, not CISF, my lord. CISF. I want to use the exception to this affidavit filed by the respondent authority. It is my prayer.
Matter is heard in presence of the learned advocates representing the parties. Stop. Next paragraph. In terms of the previous order, dated 2nd December 2025. An affidavit, a short affidavit is filed. By the respondent number 5, affirmed on December 11, 2025, and same is taken on record. Next paragraph. At the next paragraph. In the affidavit filed today, it is disclosed in paragraph. It is disclosed that during driving test, Petitioner started the vehicle.
And my lord,
Started the light motor vehicle. Started the
Section
light.
194B of the Motor Vehicles Act says that the
Start-
penal provision.
Started
1,000
the
rupees
light
fine.
motor vehicle. By pressing key without wearing seat belt. As a result whereof motor vehicle inspector had to abort a BORT. Driving test as driving a motor vehicle, a light motor vehicle without wearing seat belt is impermissible. Next paragraph. On learned advocate representing the petitioner has relied upon clause 11.5 of recruitment of clause 11.5 of notice relating to recruitment of constable slash driver and constable slash driver cum pump operator within bracket driver for fire services close bracket in CISF 2024. Wherein it is provided that who qualify in the physical efficiency test, comma, physical standard test and document verification will be put through the following, driving test for light vehicle, comma, driving test for heavy vehicle, and practical knowledge of motor mechanism and ability to carry out minor repair or vehicles. Stop. Any candidate who does not, it is also provided therein that any candidate who does not secure the minimum qualifying marks in these tests shown against each will be, now in these tests shown against each dorkar nei, in these tests will be eliminated from that particular stage by issuing a rejection slip and will not be allowed to participate in the further recruitment process. Stop. Stop. It is contended that since petitioner was not permitted to complete driving, was not permitted to complete light vehicle driving test, question of allotting marks does not arise, and acts and actions of the respondent authorities are contrary to clause 11.5.1. Stop. Next paragraph. The provisions as contained under clause 11.5.1 does not come in aid of the petitioner as the petition, as the driving, as light motor vehicle driving test had to be aborted by motor vehicle inspector since petitioner started driving by pressing key without wearing seatbelt. So, next paragraph. Moreover, based on case made out, court was considering previously the document dated 12 November 2025, whereby petitioner was disqualified in driving test, does not bear reasons. But it appears that petitioner signed at the bottom of the said document dated 12 November 2025, certifying that he was told about the grounds of his rejection. Next paragraph. Since purpose of filing affidavit on behalf of respondents in terms of the order dated 2nd December 2025 is to disclose reasons as to why petitioner was disqualified in light motor vehicle driving tests, court finds there is no necessity to file exception to this report সেন্টেন্সটা কি বলতো না না বাকিটা কেটে দাও হ্যাঁ filing of exception to this report is not called for, though prayed for. Stop. As it is, as it is averred in paragraph 7 of the writ petition, that when the petitioner pressed the key for starting light motor vehicle and shifted the gear, respondent authority / examiner asked the petitioner to get down from the vehicle, which corroborates the statements made on behalf of the respondents in the affidavit, which corroborates statement made on behalf of the respondents in paragraph 7 and 8 of the writ petition, paragraph 7 and 8 of the affidavit, which is filed today on behalf of the respondents. Stop. Nowhere in the writ petition it is averred that petitioner, after fastening the seat belt, FASTENING, fastening the seat belt, started the light motor vehicle during driving test. Stop. Therefore, calling for exception to this, to the affidavit filed today will not improve the case of the petitioner further.
The Motor Vehicles Act does not show.
Next paragraph. Hence, no relief can be granted to the petitioners. The writ petition stands dismissed.
Deep level agents. Get good. But may I get back the notification?
Yes, you will get it back after putting signature. Yesterday's matter also, I directed my PA. You will get it back because there are certain corrections. That's why it was. Give it. Yes, next.
7.
Matter
relative family pension of unmarried daughter, Lordship.
Working where? Where employee was working where?
West Bengal State Electricity Distribution Company Limited.
West Bengal State Electricity
Distribution Company Limited.
WBSCDCL.
Yes. She retired in the year 89. And
Now also, now you are also doing matters relating to WBSCDCL. Started doing matters.
pension matter. For
Yes. Yes, yes. What is the matter about?
father died 27th December 2000. Thereafter, Lordship, mother died.
Family pension in favor of daughter, unmarried daughter.
Yes. She
Yes, yes. Father died on
Lordship 27th December 2000.
2000.
2000. Mother died, Lordship,
When retired, father?
retired 89.
Date?
Date is not mentioned, Lordship. In the year 89.
Date is not known. Then father was receiving pension.
Yes, Lordship. And
Then mother, when mother died?
mother 8 April 2017.
8 April
2017.
2017. After death, you are claiming pension.
Yes, yes, Lordship.
When he made application?
Lordship, immediately after death, but I have deposited the application. I did not have the copy, Lordship. But come to the page 26, 27. First rejection order, Lordship.
Rejection order is there.
Yes.
Page 27.
Page 27. Got it, Lordship?
Public Service Regulation 1985. Yes, 2021 order.
This was not challenged.
Lordship, I have challenged that. I am coming thereafter, Lordship. Thereafter, I have also applied family pension and I deposited the income certificate. And that also rejected, Lordship. Come to page 33.
No, it says that under DCRB regulation 1985, you are not entitled.
Therefore, Lordship, come to
Well, so
33.
therefore, the respondent authority did
without
not
mentioning age of the same
request to submit documents.
Yes,
It was not due to failure on your part to submit documents.
Lordship.
It says that under DCRB regulation, you are not entitled.
Lack of knowledge of petitioner, obvious, maybe, Lordship, the office told her.
Whether this was challenged,
Yes, Lord.
when it was challenged.
Next was it. Lordship, come to the prayer, Lordship.
Page
I-
26
So
not.
in this writ petition, you have challenged.
Yes, sir.
2021
After
order.
setting aside the memo dated, Lordship, both memo, Lordship.
After 4 years,
Yes, Lord.
already your claim has been rejected. So let it be decided on affidavit.
Again, I rejected, Lordship.
Another rejection order is there.
Yes, yes,
Where is that?
That
Page
is the
33.
page 33.
Previously regretted by letter dated 21st October 2021. It's not nothing but a reiteration of the previous order.
Yes, Lordship.
The claim upon waiver it is standards.
My income is, Lordship.
Why he petitioner will not get unmarried family pension being unmarried daughter?
2021, our regulation at that point of time, at the time of the death of the mother of the petitioner, 2,600 was the limit to be eligible to be granted pension. Now, that point of time, the document demonstrated by the petitioner that she was having 3,000 rupees. No, she was not eligible. That was communicated.
So mother was not getting pension.
Mother was getting pension, but the unmarried daughter.
Yes, minimum maximum the income limit was 3,000.
3,000.
Now it has been enhanced to 9,000.
9,000, that is with effect from 2022. That amendment was made in the rule. Now she wants to have a retrospective effect of that particular. That is not permissible.
Retrospective effect
of the amendment of the rule. That was done in that 2022. 2021, she was not eligible because she was having 3,000 rupees. And admittedly, 2,600 was the limit. Yes, it was
2,600 was limit.
That
not 3,000.
Not 3,000. So that was rejected in that 2021. Now, after the amendment, now taking.
But that is not spelled out in the rejection order of 2021.
That is not spelled out. Now, DCR.
Now, what is the reason assigned? What is the reason assigned? Reason assigned is that cannot be accepted as per DCRB regulation 1985.
That is
because income cap was 2,600, and if it is above 2,600, then the candidate is not entitled to get. Now, where is the reason given?
That is not there. That is not there. I had a talk with my officers, my lord. That is not there.
No, nothing.
My lord, if you want, my lord, we can my lord, give an elaborate, my lord, explanation for rejection of her claim. That we can do. Lord, you can direct, my lord, we can, my lord, supply. But my lord, the rule is very
clear. And the second communication dated 30th May 2025 is the reiteration of the previous order.
Because the case was being considered, my lord, on the rule.
Now it has been enhanced from 2,600 to 9,000.
9,000. That is with effect from 7th July 2022.
9,000. From 7 July
2022.
And rejection order, Lordship, 2,000.
What is the present income of the petitioner?
3,000.
So now petitioner is entitled.
But my lord, the case is being, my lord, taken note of, my lord, with effect from the death of the mother when she became eligible. The rule that was prevailing at that point of that was made applicable, and 2020 it was rejected. That was not challenged.
But if subsequently the family income, if subsequently income of the applicant is enhanced to it remains same, and the higher limit or income limit is enhanced from 2,600 to 9,000, why the candidate will not get
eligibility?
At that point of time, she might not be, might have been found to be not eligible.
Yes.
But now she is considering the enhancement. Why her case will not be considered?
Eligibility started.
Show me the provision.
Well, her eligibility started from the date of her mother.
Yes.
So, my lord,
court is not saying that you pay family pension during the period when the limit of family income was 2,600.
Yes.
But after enhancement with effect from 7th July 2022, why petitioner will not get?
Lordship, kindly may place, my lord,
The amendment order, Lordship.
Till she is unmarried daughter.
Yes. Lordship, kindly see, my lord, page 19. Rule 19.
Also, I have annexed.
You have annexed?
Yes, sir.
Where it is?
Rule 19, I have annexed.
দেখি বইটা দাও।
Amendment also annexed.
Respect of pension. So unmarried daughter beyond, it is beyond the age of, age is above 25.
Yes.
Unmarried daughter beyond 25 years of age will be eligible for family pension subject to her income being less than 2,600 per month from all sources till marriage or death, whichever is earlier and thereafter. Now, if the income subject to the income being less than two, if the income limit is enhanced from 2,600 to 9,000 rupees, then subsequently petitioner should be made eligible.
But my lord, her eligibility, my lord,
No, that is not in perpetuity.
but my lord, in fact, my lord, the
Court will not direct you to pay ADR benefits when 2,600 was the was the limit. But after enhancement from 2,600 to 9,000 rupees, petitioner is entitled to get.
no, my lord, so far, my lord, the amendment to the rule is concerned, my lord. The amendment, my lord, my respectful submission, my lord, will decide it, my lord, whether, my lord, any amendment of the regulation, my lord, can have any retrospective effect or not.
Court will not give any retrospective effect. Court will give it prospective effect so far the payment of family pension is concerned.
Her eligibility arose on the death of her mother.
Yes, but that is not crystallized in view of the subsequent enhancement. It is not a case of appointment on compassionate ground. It is a case of family pension which is required to be interpreted liberally. What you are submitting?
True, my lord. But my lord,
It is not a case of appointment on compassionate ground, Mr. Chattopadhyay.
I appreciate, my lord. I appreciate what is following from my lord, my lord. But I had a talk with my officer, my lord. The difficulty is, my lord, in that event, my lord.
It's a beneficial scheme. It requires to be interpreted liberally. Otherwise, whole purpose of enhancing the limit from 2,600 to 9,000 will be defeated.
No, that will be made applicable, my lord, eligible, my lord, the persons who died after the, my lord, amendment came into effect. The persons who
think about the position
There is no
that,
mention, Lord.
please wait. Think about the position that from 7 July 2022, on 10 July 2022, if an unmarried daughter's family income is per month is 5,000 rupees, and another daughter's income is was 2,600 rupees or less than that. Both will get, but there will be another class of unmarried daughters that since their case was decided prior to 7th of July 2022, they will not get family pension. But similarly circumstanced other group of unmarried daughters or widowed daughters, they will get family pension since their entitlement was considered after 7th of July 2022 on the anvil of enhancement.
But my lord,
it doesn't make any sense.
No, true, my lord. But my lord, what?
And also in the state government, other department, you obtain instructions. This point is never urged after enhancement.
Let me come back on Monday. Let me take instruction. Let me come back on Monday, my lord. I'm getting, my lord, the points taken by your lordship, my lord. The difficulty is, my lord, in that event where the floodgate will open.
Yes, those who are entitled to get, they will get it.
My lord, let me come back.
Otherwise, the purpose of enhancing the limit from 2,600 to 9,000 will be defeated.
No.
And the court is not considering appointment on compassionate ground.
Will be made
That the scheme which was prevalent on the date of death, and now it is at the time of consideration of application after the law laid down by the Supreme Court, that will be considered. It is a case of pension, family pension. It has to be interpreted liberally. It's a beneficial scheme.
Let me come back, my lord, next month. Let me come back. I will, but definitely, I will, my lord, take instruction, my lord, as to whether, my lord, what is the situation in the other state government.
Ask Mr. Mukherjee. He regularly appears before the state government whether this point is taken in case of teachers and other employees, that after enhancement of family pension, after enhancement of limit, from the date of enhancement, eligibility is fixed or considered.
Let me come back.
What about the teachers? Same thing. It was previously 3,000, now it is 9,000, and those who had the income of 9,000 or less, they are getting pension after an enhancement.
But my lord, to become eligible, there should be, my lord, a cutoff date. Cutoff date is the date of amendment to the of the rule.
Retrospective effect can, yes, it does not have retrospective effect. That does not mean that from the prospectively it will not be applied.
But her eligibility,
Court will not direct that from 2017 to 27th of July 2022 you will pay the arrear benefits. But from 7th July 2022, petitioner's entitlement comes.
no, my lord, my difficulty is, my lord, her eligibility, my lord, I'm
Yes, sure.
sorry for repetition, my lord. Her eligibility comes, my lord, after the date
Petitioner
of
has affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next paragraph. Petitioner has claimed family pension being unmarried daughter of a deceased employee of West Bengal State Electricity
Distribution Company Limited. WBSC.
WBSCDCL, just a minute. West Bengal State Electricity Distribution Company Limited, within bracket for short WBSCDCL, close bracket. Stop. Father of the petitioner was employee of WBCDCL who died in 1989 and who retired in 1989 and died on 27 December 2000. Stop. Father was in receipt of pension till the date of his death. After death of father, mother obtained family pension. Mother received family pension till her date on 8 April 2017. Stop. Petitioner being unmarried daughter and whose age is above 25 years is claiming family pension from the date following the date of her mother. Stop. Next paragraph. Mr. Supriyo Chattopadhyay, learned advocate representing WBSCDCL, submits that previously income limit was rupees 2,600 for adjudging an applicant whether to get family pension or not. Stop. From 7 July 2022, monthly income limit was enhanced from 2,600 to 9,000 rupees, 2,600 to rupees 9,000. Stop. According to the petitioner, according to the respondents, entitlement of the petitioner is required to be adjudged on the date of mother, that was on 8 April 2017, when income limit was restricted to rupees 2,600 and petitioner had income more than rupees 2,600. Stop. Next paragraph. Question arises for consideration that after enhancement of income limit, monthly income limit from 2,600 to rupees 9,000 from 7 July 2022, whether petitioner is entitled to receive family pension as her monthly income is less than rupees 9,000. Stop. Next paragraph. Mr. Chattopadhyay has prayed for accommodation to obtain instructions. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on January 2026. Take it back.
I'm coming.
Milord, the passed over matter, Milord, item number 5, Milord, Mr. Rai Mukherjee is here.
Yes, original side mentioning.
My lord, may I mention one matter for inclusion?
Original side.
Yes, my lord.
Original side. Yes, inclusion.
Was filed on this matter filed on December, but it still did not come up in the list.
It will appear. It will appear just after or very well in next. What is the urgency?
The urgency is that the petitioner has been illegally terminated from his service without granting any
When
opportunity.
terminated? You do not know, and you are saying it is urgent. If the petitioner was terminated in 2021 and you have come after 4 years, how it is urgent? So let it appear in the combined monthly list of January 2026 under the heading court application.
Lord, may I permit to mention, my lord, in the last occasion, my lord, I have mentioned for extension of time of filing of affidavit in opposition. And lordship has
That matter is already fixed for hearing on 6th January.
7th January, 7th January.
7th January. You renew your prayer on that day.
Lord,
That's why I am directed not to appear in the meantime.
My lord, may I file affirm the affidavit, my lord?
That you can affirm and bring the affidavit on the next date. Court will
Yes,
consider.
yes, much.
My lord, may I have your lordship leave?
Original side.
No, my lord, it's
Mention on at the morning.
Well, it's from the determination of minor justice.
Maybe
That,
I mention in the morning. I am allowing everybody from determination. Not now. This is not the time to mention.
well, the interview.
I have allowed everybody to mention in the morning if it is from the determination of Justice Sinha.
May I permitted to mention one?
Don't mention.
Registration application earlier I mentioned it was your lordship directed to appear on monthly list of December, but till that it did not appear, my lord. Restoration application, my
Restoration application on original side.
lord. Original site.
Dismiss for default.
25th 7, my lord. Within time I
25th July.
of 25.
25. Within time you have filed.
Within time.
Next Wednesday.
Yes, madam. I'm granted.
May I have my lord's kind leave to mention a original side matter of 2024, although there was a direction to file affidavit by the respondent. Thrice it was extended. Affidavit has not been filed. My lord, for the pendency of the writ petition, I have challenged the initiation of the charge sheet. The charge sheet has been issued by a person who is not my appointee, rather very below the rank. But for this pendency, my benefit cannot be released.
Hearing matter, wait for some time. Now I am not.
Let it appear in the monthly list.
No. I have disallowed others mentioning of others. For the list.
Item number 1. But this item number 1 is identical to a matter which I have mentioned before your lordship of 2024, where several orders have been passed. And identical to the extent that it relates to the pay fixation of a contractual employee pursuant to the memorandum issued by the state government, which has been extended to the state transport undertakings also. But several orders have been passed in earlier writ petition, which has been.
Just a minute, let me see what was the order.
But I appeal for the Calcutta State Transport.
That I know. Last occasion I directed to serve notice. They to serve notice upon the state respondents or the learned advocate representing the representing the respondents.
I tendered unqualified.
Where is the notice?
I tendered unqualified apology, perhaps I have missed it.
Issue.
Kindly grant me one reason. It will appear after vacation.
Learned advocate representing the petitioner has paid for accommodation to serve notice in terms of the order dated 3rd December 2025. Stop. Hearing of this matter stands adjourned. List the matter under the same heading in the monthly combined list of January 2026.
Notes.
Number 2.
Number 2, your lordship, Mr. Parthok is appearing in this matter, your lordship.
Yes.
He engaged in courtroom number 29, your lordship.
Pass over. Tell him to come.
Lordship, item number 2 to 5, your lordship. Yes,
Lordship, in item 4, I am appearing. Item 2, I am appearing, your lordship. Item 4, my impediment has been that, your lordship, I had original affidavit in opposition, a report was affirmed.
On the last week, I could not appear, and the same was kept in the court records, courtroom, and somehow that has been misplaced. So that I have to reaffirm the affidavit. That
Very well. When matter will be called on, you renew your prayer. 2 to 5.
Yes, your lordship.
Ask him to come.
Lordship.
Item number 6.
Lordship, my senior is engaged in another courtroom, praying for short possible.
Who is appearing?
Akashdeep Mukherjee.
Where is he?
Is another courtroom. He's coming.
Tell him to come. Pass over.
Item number 7.
My lord, I appear for the respondent. But here, my lord.
7.
6, madam.
6. Very well. Call item number 6.
Item number 6.
This is the second round of the. His mother was the applicant for the on the basis of the no objection. He made an application for the compassionate appointment. He was given the compassionate appointment, but the nature of that was contractual. Initially, he was engaged. Thereafter, Lordship, we filed one application before this court. The Honorable Justice.
Just a minute. There are the our orders. Just let me go to the.
Lordship, kindly come to.
Just a minute. Huh?
Kindly come to page 41.
40.
40. It was the order passed by the coordinate bench in the first round of the litigation. And this will give the entire picture. The father of the petitioner was an employee of respondent number 2. The father died on November 29, 2007. During the tenure of his employment, the mother of the petitioner, being widow, first applied seeking compassionate appointment. The application was not considered and kept pending. At this juncture, the petitioner, being the son of the deceased employee, applied seeking his appointment as compassionate appointment. Document at page 17 to the writ petition dated February 15, 2011 shows the application of the son, being the petitioner herein, was under process and the authority was insisting of that. The petitioner was ultimately given an appointment as a contractual conductor, but not against any sanctioned post. The record shows that no final decision has been taken by the authority with regard to the application of the petitioner for compassionate appointment. Relying upon the order passed by the coordinate bench dated April 27, 2022 in WPO 1240 of 2021 in the matter of Upendra Kumar versus State of West Bengal and others, such and such learned counsel appearing for the petitioner submits that under the similar fact situation, the coordinate bench directed the respondent number 2 to consider the case of the applicant seeking compassionate appointment along with the consequential directions, as would be evident from the order. Such and such prays for the disposal of the writ petition in the same light as that in the matter of Upendra Kumar Supra. Respondent number 2 are not represented. This court, in the facts of the case, is of the opinion that by keeping this writ petition pending, no further fruitful purpose shall be served. Accordingly, the following directions are made. The petitioner shall serve a copy of the entire set of the writ petition with annexures along with the copy of today's order upon respondent number 4. Respondent number 4 then, upon issuing prior hearing notice or of at least 7 days to the petitioner and after granting him an opportunity of hearing, shall decide the issue by passing a reasoned order in accordance with law. The entire exercise shall be carried out and completed by the respondent number 4 positively within the period of 6 weeks from the date of communication of this order, and the reasoned order shall be communicated to the petitioner within a further period of 1 week from the date of the said reasoned order to be passed. It is made clear the court has not gone into the merits of the claim of the petitioner and the merit of the writ petition. The petitioner shall be at liberty to urge whatever point he wishes to urge by relying upon whatever records, documents, other wishes to rely upon before the respondent number 4, but the same shall not travel beyond the scope of the case made out in the writ petition. In the event reasoned decisions goes in favor of the petitioner, the appropriate authority shall give immediate effect thereto, but positively within a period of 6 weeks from the date of the said reasoned order to be passed upon compliance of the necessary formalities. It is needless to mention, my lord, this is important, needless to mention that while deciding the issue of the respondent number 4 shall also consider the order of the coordinate bench in the matter of Upendra Kumar Supra and their subsequent decision, which are made in part of the writ petition. From the document at page 29 of the writ petition, it appears that respondent number 2 has already acted upon the said decision of the coordinate bench, since affidavits are not called for allegations such and such. Well, this was done. Then, Lordship, kindly come to page 45. Hearing was conducted.
Yes.
Kindly come to page 46. So, Lordship, that was the direction, and in the light of those directions, this authority was required to dispose of my case. Page 46 is the hearing on 25/7/2025 in compliance with the direction passed such and such. 4/8/2025 in compliance with the direction of the His Lordship, the Honorable Justice Aniruddha Roy, dated 22nd May 2025, passed in.
But I'll not disturb my learned friend. Only thing, my lord, since he's placing the impugned order at page 46, my lord, when it was served upon his client, my lord, it was our mistake. Lordship will find it possibly in Lordship's brief also, it contains only 2 pages. The middle page was not served upon him by mistake. Subsequently, it has been served. He has got a copy. My lord, I'll request your Lordship to go through this, which will, because this is not the full order. The middle page, I do not know why it was not served, it was missed.
That was served later on.
Yes, yes, but before moving out. So, এটা place করে লাও হবে না।
After receiving the contempt.
Contempt আবার কেন হবে?
Mr. Bihani.
তুই তো পেয়েছিস।
Compliance with the direction of his Honorable Lordship, the Honorable Justice Aniruddha Roy, dated.
Now, where is the scope of passing interim order?
But Lordship, kindly, there is a scope of disposing the writ petition in view of this, because Upendra judgment is very clear that what is to be done. It is respect of the same Lordship body, that is the CTC. Now, the argument they have placed here, possibly Lordship can find out, if your Lordship read Upendra.
Coordinate bench directed that Upendra Rai's judgment would be considered.
That was not called. In Upendra Rai, what happened? The same facts, same similarly placed candidate was considered for the purpose of the compassionate appointment. So they accepted there was existing scheme for compassionate appointment that was given. And this was also, kindly come to page 31. This judgment is there.
But you were also given appointment on compassionate ground, but not against the substantive post.
That was decided in the Upendra's judgment, and ultimately Upendra got the job in the against the sanctioned post, against the permanent vacancy. That was the full, because the main argument there, which was considered by this court, was that the scheme, where there is a scheme for the compassionate appointment, it should be, Lordship, against the permanent vacancy sanctioned post, not for any contractual vacancy. That was the, Lordship, kindly come to page 31. This is the judgment of Upendra. That gazette notification after Upendra. This was the gazette notification. Lordship, whereas in pursuance to the labor departments, the governor is pleased to formulate the policy. This is the policy. And
it was considered in Upendra Rai, this notification. It is a notification dated 13 January 2011.
That was the scheme
of the transport department.
And this is the judgment, and it is handed over.
Well, page 32 is the notification after Upendra.
32 is the
After
Letter to Upendra of pursuant there.
this was considered by them. 32. Whereas the Honorable High Court Calcutta in such and such decision directing the state to consider the petition. And whereas the Honorable High Court Calcutta has been pleased to issue the Sir Vinod Kumar, the Principal Secretary, Transport Department, such and such. Whereas the West Bengal Transport Department, Lordship kindly straight away come to last paragraph.
page 32.
Page 32. 1, 2, 3, 4, 5. Paragraph 5 onwards. And whereas on 19th May 2023, the Honorable High Court Calcutta has been pleased to direct the Managing Director, West Bengal Transport Corporation, to issue fresh appointment letter in favor of the petitioner after deleting the portion that the appointment is subject to the result of this an appeal. Now, therefore, pursuant to the solemn order dated 19 May 2023, passed by His Lordship the Honorable Justice Arindam Mukherjee in respect of CC 60 of 2022 with WPO 1240 of 2021, you are hereby appointed conductor in regular cadre with effect from 18/5/2023 forenoon under control of the Deputy Managing Director, Tram and Bus. You will be entitled to the pay scale such and such. Now, this was passed in pursuance to the order of
Upendra
Kumar. Now, in my case, that was not considered. May I read the reasoned order passed by them? Lordship, I am invited to Mr. Bihani that he has handed over me the copy of the entire copy. I was not served, admittedly.
They subsequently served, but when you have the board.
May I read it? In compliance with the direction of the His Lordship, the Honorable Justice Aniruddha Roy, dated 22nd May 2025, passed in WPO 1336 of 2023, the matter was taken up for the consideration. The petitioner Sri Joy Das was heard in person. The petitioner contended in his writ application that his father was an employee of CSTC and expired on 29/11/2007. At the time of the death of his father, he was a minor. Therefore, his mother, Srimati Deepa Das, applied for the appointment on compassionate ground. He alleged that he made several correspondences, but he was not offered any employment on compassionate ground. But there is nothing to show as to when and how the writ petitioner submitted his application for appointment under compassionate ground in writ application. He submitted that in June 2020 he was appointed as conductor in CTC through agency. He cited an instance of the appointment of Upendra Kumar in West Bengal TCL CTC on compassionate ground. He thus prayed for the appointment on compassionate ground on a permanent post. It appears that there was a compassionate appointment made in CTC at the instance of a court order dated 27/4/2022, passed in WPO 12401 of 2021, and that too was under the direction of the Government of West Bengal in Transport Department. In the writ petition is stated and contended that the respondent number 2, a government company registered under Section 617 of the Companies Act 1956, that is out and out a misleading statement. The father tried to mix the West Bengal Transport Corporation Limited with Calcutta State Transport Corporation, which are two separate legal entities. The Calcutta State Transport Corporation was never been transformed to West Bengal Transport Corporation Limited. However, it transpires from the records, at least till 9th April 2003, there was no scheme for compassionate appointment whatsoever in the corporation. It was pertinent to state that any such scheme would be framed and or floated or approved by the Transport Department, Government of West Bengal. It reveals from the record that the Government of West Bengal Transport Department, by its memo number 1345 WT dated 9/4/2003, as one-time measure conveyed its proposal for employment on compassionate ground against the die in harness category only for certain specific number of enlisted candidates seeking appointment of compassionate ground under die in harness category. With the passage of time, after absorption and or offering those candidates appointment on compassionate ground in the corporation, the said one-time approval and or the said one-time scheme for compassionate appointment does not exist. But that as it may accept such a one-time approval for the appointment of the corporation against a specific number of candidates in die harness category, neither at the relevant time for at the present moment there is any scheme for appointment on compassionate ground either on die harness category or in any other category in the corporation. Undoubtedly, the objective of granting compassionate appointment is to financially assist the bereaved family and provide immediate succor by averting the financial crisis that the dependents and the deceased employee may face due to sudden death of the breadwinner of the family, provided that is scheme of such employment on compassionate ground. In fact, the Labour Department, Government of West Bengal, filed notification number 251 dated 3rd September 2013, withdrew and or superseded its all previous orders or notifications regulating the appointment of the compassionate ground and thereby restricted the scope of such scheme for compassionate appointment. In 2013, by issuing a notification number 251, it has been specifically mentioned that the scheme for compassionate employment is only for the employees of the state government department, and all the earlier notifications issued for compassionate employment have been superseded by its notification of 2013. In fact, there is no scheme after 2013 in any manner whatsoever in CSTC or any of the STUs. As such, in absence of scheme, prayer for compassionate appointment cannot be exceeded. It is pertinent to mention.
Yes, where is the scheme?
Now, there is this scheme. Lordship, kindly come to page 19.
Because you were appointed in CTC, Calcutta Tram Company. That is through agency. It has got nothing to do with the
Not CTC, CSTC.
Calcutta Transport Company.
He was appointed in CSTC. Upendra Kumar Roy was in CTC.
In
June 2020, he was appointed in CTC. It is stated the writ petitioner submitted his application for appointment under compulsion. First page, second paragraph.
Yes. Alright, Your Lordship, this is
He submitted, and in June 2020, he was appointed as conductor.
that was his submission.
CTC.
CTC. Actually, his appointment is in CSTC.
Calcutta State Transport
Upendra Kumar Roy's case, he was an he was an employee of CTC.
There cannot be any
No, let him complete. Let him complete.
No, but what is the scheme? If there is no scheme, question of
kindly come to
appointing compassionate on compassionate ground does not arise.
Page 19. Once. Lordship, kindly come to page 19, Calcutta State Transport Corporation. This is dated 2011 with reference to his application for employment in CSTC. Page 19. With reference to his application for the employment in CSTC.
Just
on
Yes.
This is dated 15 to 2011. My lord, then kindly come to page 31.
Where is your application for appointment on compassionate ground?
Application was there, that's why it was considered this was issued.
Now, what was your age on the date of the employee?
That looks well.
In 2007, expired on 29th November 2007. What was your date? What was your age?
My today his age is
32 years at present. At present, 32 years in 2007.
My mother applied first
So
initially.
show me that you have a right being minor.
Mother applied, my lord.
Maybe mother had the right, but a minor on the date of death, unless scheme provides, you have no right.
Yes, I'm giving.
Show me the scheme. Under the scheme that a minor has got a right.
Kind page 31, my lord. This is dated 13/1/2011. This is the scheme. That's why, Lordship, I referred to.
How that is applicable when employee died in 2011?
But kept pending, application was kept pending, my lord. Application was kept pending.
Application of mother kept pending. Show me from the scheme.
That's why I'm reading.
Yes.
May read. My lord, whereas the pursuant to the Labour Department notification number 142, employment such and such, government is pleased to formulate the policy with the prayers of the appointment of the financial assistance on compassionate ground received by the state transport undertaking from the dependents of the employee of STUs. STUs who die in harness.
Please take me to the relevant provision where, no, please don't read the entire thing. Please take me to relevant provision from where it can be construed that the minor on the date of death of the employee, minor son or daughter is entitled to get appointment.
My lord, kindly come to page.
এরকম annex করা হয়নি তো আছে page
This is the division bench judgment
30
on this issue. Yes.
Page 34, my lord. Kindly come. Okay. Page 35, 7. The dependent of the employee seeking appointment on compassionate ground shall hence make an application in prescribed form.
35(7).
7. Deceased employee is retirement from the permanent disability. If no application is submitted within the stipulated period, it will be presumed that a family does not require immediate financial assistance. On receipt of such application, the appointing of the organization shall form inquiry committee, senior officials not less than 3 number. The committee will form a condition as invested CD in Labour Department notification will be fulfilled for the appointment. The organizations have to keep their hand strictly. Lordship, this condition, Labour Department notification.
Show me the provision that on the date of death, minor has the right. If the dependent son or daughter is minor, he has right to be considered for appointment on compassionate ground.
Lordship,
Please
they
show me.
kept it pending. They kept
I want a provision in the scheme granting, conferring right upon a minor son and daughter to be appointed on compassionate ground. There is a judgment by the division bench presided by Justice Dotto that on the date of death of the employee, if son or daughter and dependent or any eligible dependent member is minor, he has no right unless scheme provides. Show me the scheme.
May I consider the judgment and come back?
It's not necessary. Subsequently, I authored a judgment sitting with Justice Dotto, Azim Gaji on the same point.
Lordship, may I come back?
Yes, no, you show me from the scheme. I asked you that what is the provision, what is the scope of interim order?
Yes, ma'am.
You have already argued for last 25 minutes. You show me from the provision that there is a scheme.
Yes.
So you show me from the scheme that there is a provision that a minor has got a right to be considered for appointment on compassionate ground.
I made an application in 2011 when I was major.
You are major in 2011.
2011, that's why I made the application. My lord. That was this letter was addressed, my lord, to me.
No, please calculate if today your age is in 2025, 32 years, then in 11, 32 years, then 32
years
in, if it is 30, the employee died in 2007. Yes, 29 November 2007. Then your father died 23 and 25 years before. So 32 minus 25.
It's 25 years.
Yes,
It should be.
employee died, employee expired on 29 November, come to the impugned order, Second paragraph, petitioner contended in his writ petition that his father was an employee of CSTC and expired on 29 November 2007. Meaning thereby, today we are in 2025, then 13 plus 5, 18 years back. So 32 minus 18?
32 minus 18, my lord, 28.
15 দরকারই কি অর্ডারটাই ক্লিয়ার
That was considered.
32, 22, 8, 15 years. You are not major. You have no right to be considered for appointment on compassionate ground.
That was considered, my lord.
Show me the provision, I am ready to accept it. If the provision, if it is provided in the scheme, otherwise not.
My lord, now the question is.
Yes, Mr. Mr. Biani, whether is there any scheme?
Just 2 minutes. Firstly, my lord, kindly, I'll just take 2 minutes. I know lordship is before vacation hard place. Kindly takes only one paragraph. I shall not place the impugned order, which I have handed over to your lordship, my lord.
Yes.
The impugned order, my lord, which I have handed over to your lordship. My lord, kindly take the second paragraph, which just fell from your lord. The second paragraph, the first page, second paragraph. The petitioner contended in his writ application that his father.
Sentence stands undoubtedly.
No, the petitioner contended. First page, second paragraph.
Oh, first page.
Lordship. The petitioner contended in his writ application that his father was an employee of CSTC and expired on 29/2007. At the time of the death of his father, he was a minor. Therefore, his mother, such and such, applied for appointment compulsion ground. He alleged that he made several correspondences, but he was not offered any employment in the compulsion. But there is nothing to show as to when and how the writ petitioner submitted his application.
That I have seen.
Now, but bereft of this. Number one, no, there is no scheme in CSTC. There may have been a scheme in CTC, not in CSTC. Now,
where Upendra Ray's case was considered.
I'll come to Upendra Ray's case. Well, Upendra Ray was CTC, not CSTC.
Yes.
Now,
in CSTC, there is no scheme.
That is recorded in the order also. I'll show you.
Yes, that is the purpose.
Now, he has referred to 2 pages. Kindly take page 19. Oh, that I'll tell you, lordship. 19 is of 2011. Page 19 is of 2011. 19 is to 2011. I will not place it. Just the date. It is 2011. Well, kindly do not go through it. I take his words that whatever he says is correct. 19 is of 2011. And page 31 he has relied upon is also of 2011. Now, my lord, the position is this. If your lordship goes to the impugned order, your lordship will find. Just kindly take second page of the impugned order. My lord, the third paragraph, it starts with now undoubtedly, which as lordship was saying. Undoubtedly, the objective of granting compulsion appointment, my lord, kindly goes, provided there is a scheme for such employment on compassionate ground. In fact, then kindly say, in fact, the Labour Department, by notification of 3rd September 2013, withdrew and or superseded its all previous orders and notifications regulating the appointment on compassion ground, thereby restricted the scope of such scheme for a compassion appointment. Number one, 2011 goes. Number two, as early as in this 24th January 2025, my lord, handing over to your lordship, the state government writes to the secretary to the Minister of Transport Department, saying that there is no scheme. If there is any other order after this 2013 Labour Department, everything goes. Not only in CSTC, in everywhere, everything goes. So now, what? Record. এক সেকেন্ড দিয়ে দিচ্ছি তোকে। দাঁড়া একটু দিচ্ছি, ওন করছিস কেন? পড় না বলছি, করিস না, এটাই তোকে আমি জেরক্স করে দিতে। কদিকে দেবো না দিয়ে দাও, আরে ভালো ওকে বলতে হবে।
Yes.
Number one thing, only as apropos this, kindly see paragraph 4 of that order. As of now, there is nothing. As of after 2013, there is nothing. Even prior to 2013, that was a different question. After 2013, Labour Department's notification.
Yes, as it is referred to 251 EMP dated 3rd September.
I'm deeply obliged. That is reflected in
all other schemes.
That is reflected in the impugned order also. So after 2013, there is no scheme, and CSTC does not have a scheme.
And the case of Upendra is in case of CTC.
CTC.
Well, so far this contention is there. My answer is there in page 31. First
And moreover, a minor has no right at all.
31 is of 2011.
I have to convince you.
Case
Lordship, on
31
that
is of
point.
You will
2011.
convince me.
I'll have to convince.
Yes.
Otherwise, I am out of the court.
Case 31 is of
Page
2011.
Paragraph 1. STU means the state transport undertaking of the government of West Bengal. State policy is applicable to the STUs under transport department, namely North Bengal State Transport Corporation, Calcutta State Transport Corporation, Calcutta Tramways Company CTC, and West Bengal State Transport Corporation. So, Lordship, this distinction is not standing in the eye of law. So the same policy is followed everywhere. The state cannot follow one policy in terms of one transport corporation and other in terms of other. The scheme is same.
Well, the admin is in, I'm sorry.
Yes, go on arguing. I am hearing.
Not the, if your lordship takes in another way, lordship is asking me to argue on Mr. Chatterjee.
Both will argue side by side. Yes.
This is
Yes, Mr. Chatterjee.
My lord,
And Lordship, kindly now let me read Upendra, and then your Lordship consider this Upendra whether it is applicable in my case.
আচ্ছা নিজে জাজমেন্ট করছে প্লেস করলি বললাম এফিডেভিট করবো এফিডেভিট বুঝতে বল না কিন্তু whatever Mr. Gani is saying, let him come on affidavit. But অপোজিশন বলিস না ফালতু করছিস কি করছে sorry. তুই দুটো শ্যান্নাল আর তোমার সেন বলে একটা মেয়ে আছে গুড গুড টিম অরিন্দম ব্যানার্জি আমার টিম নিয়ে চেয়েছিলাম আমরা সুতপা জোন দুজনেই বা প্রতীকদা তোর আর দিয়ে তার নামটা আমার থেকে আর জয়ন্ত এই চারটে নাম আমার থেকে তোর তো বদমাস ওটা জয়ন্ত তো আমার ব্যাগ না
Yes.
May I place Upendra's judgment once?
Upendra's judgment.
Because of similar situation, also I said.
How it can be similar situation because two organizations are different. Even if Upendra's judgment, there is a direction for appointment, but it is a case of right of a minor to be considered for appointment on compassionate ground. if the petitioner was minor on the date of death, as it is recorded in the impugned order, you have no right, unless scheme does not provide.
That is no, has coming from your lordship's mouth today. Lordship, that question I will have to answer.
Yes.
It is coming from your lordship.
No, it's not. It's a settled position.
Yes, my lord. That
It is settled position.
is not taken by them.
Yes.
Coming from the bench, my lord.
It's
It's
in the
not a
order.
part of the impugned order.
It's
which
in
I'm
the
telling.
part of the impugned order.
But impugned order doesn't say that it was minor and.
हाँ बोलेছে এই তো first পাতা
No, that says where there is no documents. There is a different, my lord, in my reading, subject to correction.
Yes.
I say, my lord, these or state cannot say that they can be discriminated on the basis of the different organization. That is controverted by paragraph.
Whether Upendra was minor
Yes.
on the date of death.
That answer I will give. Lordship, STUs are STUs. They cannot distinguish between CTC and CSTC.
Yes, yes.
As per section paragraph 1 of page 31. Lordship, kindly come. STU means what is state transport unit, means state transport undertaking of the government of West Bengal. So all the state transport undertakings of the government of West Bengal were guided by the same notifications in respect of the compassionate appointment. Now your lordship wanted me to address your lordship on the question that whether the minor there was a provisions under the scheme for minor can apply or not. Now lordship kindly come.
Yes.
For the purpose of the appointment of the financial compassion appointment ground, the dependent of an employee shall be mean wife, husband, unmarried daughter, employee who was solely dependent on the employees. One of the dependent of the employee who died in illness, who retires permanently on being declared incapacitated. Now, lordship kindly come here also. Lordship, so far this policy says there is no express permission. I say, Lordship, if your Lordship grant me time, I can come.
No, there is no question of granting time. It is settled position. Division bench judgment. I was author of a division author of one judgment. Azim Gaji. I was part of that division bench. After that, it is settled.
But in case of Upendra, Lordship, kindly consider the Upendra judgment.
How Upendra will be considered? If it was not a case of minors' right. It is not a case of minors' right. Upendra will not come in the way.
Kindly come.
I will not consider. If you can demonstrate that in Upendra's case, minors' right was considered, then I will consider it.
May I go through this Upendra's petition and come back?
Yes, sure.
That I have.
In the writ petition, order of Managing Director, Calcutta State Transport Corporation, dated 4th August 2025. 4th August 2025 is questioned as now whereby prayer of the petitioner for appointment on compassionate ground was panned. Stop. Father of the petitioner was an employee of of Kolkata State Transport Corporation within bracket for short CSTC close bracket, and who died in harness on 29 November 2007. So, at the time of death of father, petitioner was minor. Stop. After death of father, petitioner's mother applied for appointment on compassionate ground. Stop. Previously, a writ petition was filed being WPO 1336 of 2023 within bracket Joy Das versus the state of West Bengal and others, claiming appointment on compassionate ground, wherein a coordinate bench video order dated 22nd May 2025 disposed of the writ petition, thereby directing the concerned authority of CSTC to take decision in accordance with it, relating to claim of the petitioner seeking appointment on compassionate ground. Stop. However, in the said order dated 2nd May 2025, all issues were kept open, and there was a direction.
I'm sorry to interfere, madam. Kindly see
That the order passed on 27th April 2022 in the writ petition being WPO 1240 of 2021 within bracket Upendra Kumar versus state of West Bengal and others requires consideration by the concerned authority of CSTC while deciding the claim of the petitioner for appointment on compassionate ground. Stop. Next paragraph. It is submitted by Mr. Chatterjee, learned advocate representing the petitioner, that while deciding the claim of the petitioner seeking appointment on compassionate ground, video impugned order dated 4th August 2025, order of the coordinate bench in Upendra Rai Supra, Upendra Kumar Supra was not considered, and due consideration of the ratio of Upendra Kumar Supra would have changed would have altered the situation, and claim of the petitioner would have been decided otherwise. Next paragraph, Mr. N.C. Bihani, learned senior advocate representing CSTC, has opposed this writ petition based on the decision taken by the managing director CSTC dated 4th August 2025. Stop. It is submitted all previous orders and or directions relating to appointment on compassionate ground were either withdrawn or superseded. Vide notification number 251-EMP capital dated 3rd September 2013, issued on behalf of the Labour Department, Government of West Bengal. Stop. Relating to claim of the petitioner for appointment on compassionate ground based on ratio of Upendra Kumar Supra, it is submitted that it was a case under CTC. It was a case under CTC, full form Calcutta Tram Company.
Tramways Corporation.
Calcutta?
Tramways Corporation.
I will just check now.
Company na corporation, Baba?
Calcutta Tramways Company and it's
Company.
It was a case of Calcutta Tramways Company.
Limited.
And in the present case, petitioner is seeking appointment under CSTC. Moreover, it is asserted that there is no scheme prevalent which confers right upon dependent family member of the deceased employee to get appointment on compassionate ground. Next paragraph. On submissions being made on behalf of the parties and taking note of the relevant materials available on record, it is found that nothing is demonstrated demonstrated which shows existence of a scheme relating to compassionate appointment as on date, which could have been pressed into service in order to decide the claim of the petitioner. Stop. Moreover, on perusal of the impugned order dated 4th August 2025, it transpires that all previous orders and or notifications regarding appointment on compassionate ground were either withdrawn or suspended. Vide government notification number 251-EMP dated 3rd September 2013. Stop. Next paragraph. In absence of valid scheme, right of a dependent member of a family of right of dependent family member of deceased employee who died in harness cannot be taken into consideration. Stop. Next paragraph. Moreover, what is striking, that petitioner was indisputably minor on the date of the employee on 29th November 2007. As it it appears from the affidavit in connection with the present writ petition that present age of the petitioner is 32 years. Therefore, on the date of the employee on 29th November 2007, he was minor. Stop. In the case relating to appointment on compassionate ground, unless scheme provides a minor at the time of date of employee has no right to be considered for appointment on compassionate ground. Stop. In this regard, reliance is placed on so and so. Stop. Next paragraph. In view of aforesaid situation, no relief can be granted to the petitioner. Stop. Writ petition stands dismissed. Urgent xerox.
Well, only one thing, since I've handed over the impugned order today, the full order in court, Lord, kindly keeps it on record.
আচ্ছা, ওখানে মিস্টার বিহানির যে সাবমিশনটা ওইখানে একটা লাস্টে বলে দাও, ফুল কপি অফ দ্য অর্ডার ডেটেড 4th August 2025 passed by the managing director CSTC is filed today and semi-step.
I'm deeply obliged.
It is Anirban Choudhury and another 2 matters of WPST was decided by Justice Dotto sitting with Justice Vivek Choudhury. Anirban Orindam.
There are 2 persons.
Anirban Orindam. It was decided there. It was the eligibility were laid down in vividly, and where it is specifically held that in absence of a provision in a scheme, minor has no right. Relying upon Orindam Onirwan, I delivered a judgment sitting with Justice Dotto. I authored a judgment. That was a case of Azim Ghazi versus State of West Bengal and others. And the recent judgment of Justice Dotto in Supreme Court, Ajit Kumar GK.
Yes.
Nothing remains. If you are a minor, yes, it can be considered if scheme provides. Otherwise, not. If scheme is silent on this issue, you have no right.
Point number 7. Petitioning this matter, my lord. Here, my lord, up to 35 years. Up to 35 years, the petitioner is entitled for employment. Up to 35 years of age, the petitioner is entitled for employment. Now, my lord.
Compassionate ground.
Yes, my lord. Conversion. Now,
you are confident to get the matter heard now after previous matter. It is different. Factually, it is different. Very well.
It is covered by your lordship's order.
First, my lord.
It is covered by your lordship. No, earlier order is there.
Earlier what order, my lord?
Earlier order is there.
No one appeared. That's why no hearing.
After twice, my lord.
What he said.
My learned friend, my lord.
What my learned friend?
Wake up, my lord. Matter was taken up twice.
Kindly take up.
Matter was taken up twice.
December 20.
Your lordship has already passed the order in original side. So, in a second time, my lord, your lordship. Usually, my lord, is second time, my lord.
You should have brought it to the notice of this court. How this is maintainable in the original side?
But second time, your lordship already passed the order, my lord.
A conversion order আছে না original side এর যে কোনো থেকে appellate side এ অনেকগুলো দিয়েছি তুমি নিয়েছো mention before the appellate side দেখবে তুমি আগের দিন
Number 8. I am for the petitioning this matter, my lord.
Item number 8, I have been instructed to appear on behalf of the Bharat Going Coal Limited today morning over telephone, my lord. My client also informed me no copy of the writ petition is available with him.
No, affidavit of service is there. If they, my lord, loses the copy, what can be done?
Coal India Limited is maintainable.
Coal India Limited also appearing, but they are also not found any copy of the writ petition.
Let them take instruction, my lord.
What is the matter about?
Matter is, my lord, there was an accident way back in 1993. There was a disciplinary proceedings initiated against me, and subsequently, my lord, inquiry report. Accident. Some people have died.
Course of duty.
Yes, some people have died in the underground. There is a, my lord, broken off, my lord, the wall, and water has, my lord, put into the, my lord, mines. And I was, my lord, charged on that, my lord, particular colliery, though I was not shifted on the particular time. Subsequently, my lord, inquiry was held. Inquiry officer opined that I am not guilty of the charges. Now, thereafter, my lord, the several representation has been made to them for giving me the all benefits at par with the other persons, those who have involved with me in the same incident. They have given the benefits to the similarly situated persons except the petitioner, my lord.
Benefit
of promotion, increment, etc. Whatever, my lord, attached with the service. But I am in a same position as was during that time.
Your similarly circumstanced other employees are getting benefits.
Yes.
Why those benefits are denied to you?
Nothing has been disclosed, my lord, as to why they have not.
Because a prayer made.
My lord, prayer made, my lord, if your lord kindly come. Promotion in accordance with his seniority with all consequential benefits. And I am going to return 31st May 2026. Inquiry report to query. Inquiry report. If your lordships kindly come.
You have retired in the meantime.
No, I will be retiring in May 2026. If your lordships kindly come, page.
Will take instruction, come.
P6, my lord.
Only submission, my lord.
So why petitioner is being denied the
No, I don't
benefit
know,
of promotion? Take instruction, come.
Instruction, my lord.
There's no use
One-
of hearing.
One submission, my lord. My learned friend sent to me the cause title of the writ petition, where I found that item response number 1, Coal India Limited, address 10 Netai Subhash Road. But there is no office of the Coal India Limited, my lord. That is the Rajahat is the office of the Coal India Limited. No, there is no office. I have today, my lord.
In Coal India matters, I am entertaining because they have at least an office at Kolkata.
Yes.
It should be converted in an appellate side.
Obtain instruction. Don't take this point in an appropriate case. Take instruction, come back. Issue. Matter is taken up for consideration when learned advocate representing Coal India Limited has prayed for accommodation to
Coal India and Bharat Coal Limited.
learned advocate representing, you are representing both. The learned advocate representing Coal India Limited and Bharat Coking Coal Limited has prayed for accommodation to obtain instructions. Stop. Next paragraph. Hearing of this matter stands adjourned. Next paragraph. List the matter under the same heading in the monthly combined list of January 2026.
Copy of the writ petition.
Yes, on payment of costs. Pay cost.
Number 9.
My lord, may kindly produce the last order passed by your lordship on 3rd of December. The provident fund dues has not been released. I am an employee. There was a disciplinary proceedings. After my superannuation, my service room does not permit for continuance of the disciplinary proceedings after superannuation. On that basis, my letter was issued dropping the charge sheet. So after the dropping of the charge sheet, they are required to release my retirement benefits. Only what they have released is the gratuity and leave encashment to some extent. But the provident fund has not been released, and the leave salary for the period under suspension, that has also not been paid, because final payment bill has not been issued to me, so I cannot ascertain the exact amount, and I have prayed to that extent that provident fund may be released.
When you have retired?
My lord, may kindly see the last order.
Last order?
Yes, passed by your lordship.
Just think. Just a minute. Yes. Now nothing is paid after your superannuation.
And
Not your
only-
superannuation.
only-
A proceeding was continuing against you by keeping the petitioner under suspension. Or
Yes, yes, yes. Suspension,
that suspension period, petitioner retired.
retired, and there is no provision on under my service rules for continuance of the disciplinary proceedings after superannuation. On that basis, my
Now,
lord,
what is your instruction? Whether the proceeding has been abandoned?
My lordship, we have forwarded the claim to the state on 5th June 2025. So we are waiting for the fund so that we can proceed with the
on the
payment.
last occasion, your lordship was pleased to record.
Just a minute. 5th June 2025.
Yes, my lordship.
Now, thereafter, no response.
No, we don't receive any.
Only a part of the
Now,
gratuity.
what are the dues which are required to be released in favor of the petitioner?
My lordship, we have already paid for 3,54,000
Towards
and towards the. My lordship, 1 minute. On the head of leave encashment. On the head of leave encashment. Yes, my lordship.
and what about provident fund and gratuity?
My lordship, for that we have already raised the claim to the state
Who
and
is appearing for the state?
I am appearing on behalf of a state, my lord.
Yes.
My lord, the concerned authority is not part in this writ application. My lord, please give a direction to the corporate transport corporation to provide me a copy which they have sent to the concerned authority, my lord. Thereafter, within 4 weeks, I will release the same.
State of West Bengal represents Secretary Transport Department is party.
My lord, that's why I have no documents what they have claimed, my lord. That's why I am praying before your lordship. Direct them to serve me a copy of the requisition and you may record it on record, my lord. Within 4 weeks, it will be released.
It is submitted that on 5th June 2025 claim was forwarded to the corporation, to the state authority.
My lord, but I have no information where the document,
Where is the
to
claim?
whom they have sent the document.
Show me the claim.
my lordship, I have it in soft copy. So if you allow
I
me,
know, I have directed you to obtain instruction. So it is your duty to
I
place
apologize,
on
my
record
lordship.
the hard copy of the claim.
I just received
Man
it
who
few minutes
retired
back, my
long
lordship.
back and
So,
is not getting benefits.
yes, my lordship, I
Yes.
understand.
Why you have not brought?
My lordship, please give me
3rd December 2025, directing both the state as well as the corporation to obtain instruction, and you are not without the copy of the claim.
my lordship, we have received it just few minutes back. So please allow me to come with the document, my lordship.
When you will come?
My lordship, tomorrow.
Only 4-5 days are left, and next Wednesday will be the closing date.
My lordship, tomorrow.
Tomorrow is not the original set date. It will not be taken up according to your
Yes, my
sweet will,
lordship.
madam.
Yes, my lordship.
This matter was taken up on 3rd December 2025.
My lordship, please allow me for short passover so that I can come back with the printout.
We will come back.
I'm
10 minutes, come back.
I'm grateful,
Take a
my lord.
printout,
I'm
take a
grateful.
printout and come back.
I'm grateful.
Passover. Passover.
My lord. Number 10.
This is my application.
I was selected as a clerical cadre in the State Bank of India, my lord. This was in 2012. My lord, I was appointed in 2013, 7th of January. My lord, for probation in
7th of January
2013. My lord, I was confirmed after completion of the probation period on, my lord, 16th of September 2013. Thereafter, my lord, I continued with my service. In the meantime,
as probationary,
my lord, as an assistant.
2013.
2013. My lord, my wife committed suicide on 8th of January 2014. And my lord, pursuant to the complaint lodged by my father-in-law, an FIR was initiated under 498, initially under 304B. My lord, the trial continued and my service also continued. In the meantime, my lord, I was promoted to the post of G. My lord, JMGS with effect from 1st of May 2018. In 2018, I got that. JMGS, my lord, Junior Management Grade Service 1. This was, my lord, on 1st of May 2018. My lord, the Lanet Trial Court convicted me on 29th of July 2025. Me, my father and my mother. 3 of them. My lord, against that order of conviction, I preferred an appeal. My lord, His Lordship Justice Shubhra Ghosh, my lord, suspended the sentence. This was on, my lord, 24th of September 2025.
24th September
2025.
22.
25. This year, my lord.
Yes.
My lord, I was discharged from service on 16th of October 2025. On the ground that, my lord, I have been convicted. My lord, immediately thereafter, on 22nd of October 2025, I prayed for reconsideration of that discharge.
22nd October
22nd October 2025, highlighting that, my lord, the conviction has been suspended by this honorable court.
But conviction remains. You have not been acquitted.
Not been acquitted.
It's a suspension of
Suspension of
sentence.
sentence.
So why you will be
Relying upon this judgment? This judgment. Yeah, absolutely. Ram Gopal Shikdar.
Their conviction was
stayed, not suspended.
Not suspended. My lord, that is the only difference. Lordship kindly comes to page 106.
Any other judgment?
My lord, this is the only 106, my lord. The honorable court, my lord, observed that there is remote chance of the appeal being heard in near future. In view of the above, this court is inclined to suspend the sentence of the appeal. My lord, my humble submission is, my lord, in view of suspension of the sentence, my lord, pending hearing of the appeal.
There is a judgment of Justice Bhaskar Bhattacharya that even if the order is stayed, the order against which appeal is preferred, that order does not obliterate.
But I stand corrected. My lord, only in this view of the fact, my lord, I have preferred this. If your lordship may kindly consider.
Where is the order of conviction?
Conviction order is, my lord, page 106, my lord, page 38.
Page 38?
38, my lord. The final order and it follows the judgment and order.
Page 38.
38 is the order, my lord, and the sentence your lordship will find at the after the judgment at Sentence starts from, my lord, page 100.
This is order dated, order of conviction is dated 29 July
29th of July 2025. And the sentence, my lord, starts from page
29 July 25, page 39.
39. It's the order. And the sentence, my lord, we'll find at page 100 onwards.
Page 100.
100.
And what is the order of the appellate court?
My lord, at page 106.
Tell me,
My lord.
if appeal is heard after 5 years
My lord.
and there is no interference of conviction order,
My lord.
then what will happen?
My lord, if the conviction order is
Then the conviction order which is passed by the trial court would be finalized.
My lord.
So why petitioner will be permitted to work at this stage?
My lord, this is one aspect of the matter. On the other hand, my lord, if I get acquitted, my lord, then, my lord, getting back to the work after 5 years, my lord,
Yes,
will be a difficult
yes.
task.
You will be permitted to work, and your prayer for back wages can be considered at that point
My
of
lord,
time.
This is one aspect of the matter. And the other aspect, my lord, moral turpitude, as has been, my lord, interpreted by the Honorable Supreme Court. Because initially it was, my lord, 498A and 304B. And, my lord, convicted under section 306, that is, my lord, arbitration of law.
Affidavit service to audience at 30. Matter is heard in presence of the learned advocates representing the petitioner, and State Bank of India being the contesting respondent. Stop. Next paragraph. Petitioner was an employee of State Bank of India. Which branch?
My lord, commercial branch, Kolkata.
Torkani branch, State Bank of India, who was implicated in a criminal proceeding which culminated into an order of conviction dated 29 July 2025. Passed by Additional Sessions Judge, First Court, Barashat. Stop. Petitioner along with two other persons were found guilty for commission of offense under section 498A/306/34 of the Indian Penal Code. Stop. It is submitted by the learned advocate representing the petitioner that criminal proceeding initiated due to unnatural death of petitioner's wife. Stop. Next paragraph. Petitioner preferred appeal against the order of conviction before the High Court. Being CRA within bracket SB close bracket 111 of 2025, in connection with which an application being CRAN 1 of 2025 was moved before a coordinate bench. Stop. In the application, stop. From next paragraph, from the order passed by the coordinate bench on 24th September 2025 on the aforesaid appeal and application, it appears that the petitioner being one of the that the petitioner herein being one of the appellants sought for suspension of sentence. Stop. However, coordinate bench video order dated 24th September 2025 granted bail on certain conditions, including appearance of the petitioner before the learned magistrate once in a month till disposal of the appeal. Stop. Next paragraph. Prayer is made by presenting this writ petition, which would permit the petitioner to resume his duty as an employee of State Bank of India, subject to final result of the appeal. So, in support of such submission, reliance is placed on an order passed by a coordinate bench dated 12th September 2013, in a writ petition being WPA 16734 of 2010 within bracket Ramgopal Shikdar versus the State Bank of India and others. Next paragraph. However, it is rightly pointed out by the learned advocate representing State Bank of India that in Ramgopal Shikdar Supra, order of conviction was stayed in appeal. But in the present case, prayer was made for suspension of sentence, and the coordinate bench, video order dated 24th September 2025, granted bail. Stop. Appeal is still pending for final adjudication. Stop. Next paragraph. This court cannot shut its eyes to the fact that petitioner was convicted of offense under section, convicted of committing offense which is punishable under section 498A/306/34 of IPC, and the trial court video order dated 29 July 2025 sentenced the petitioner thereby directing that the petitioner shall suffer rigorous imprisonment of 7 years and payment of fine of rupees 50,000. with default clause. Next paragraph. Considering the aforesaid facts, court is not inclined to permit the petitioner to resume duty at this stage when appeal is pending. Next paragraph. A writ petition stands dismissed. Arjun Jalak certificate, please. For
Item number 2.
Item number 2, Your Lordship, Mr. Parthok is appearing, Your Lordship.
Well, if your lordships kindly see the order passed by the coordinated bench in the earlier occasion, Lord, I have, my lord, cited one judgment covering the issue, and my learned friend is to answer that, my lord, part. If your lordships kindly see the order passed by my lord Justice Aniruddha Rai.
Mr. Ghosh convert this writ petition.
But this has
I
been
had
entertained,
also made the same thing that it
But
should
the-
be converted.
Well, it has been
And
entertained, my lord.
CL doesn't have any office in RN Road.
Well, it has been entertained earlier, my lord.
No one appears for the petition.
No, before that,
No
my
one
lord,
appears on behalf of the respondents and no accommodation. is paid.
before that, my lord, kindly see the order passed by my lord Justice Aniruddha Rai. Kindly see, my lord. I have concluded my argument.
It is not a case where your argument was concluded.
But
Nothing is recorded to such a, to that extent.
But my lord, I have, my lord, made extensive submission. My learned friend, my lord, was there. And my lord,
that is not reflected from the order dated
but today, my lord, she has to answer, my lord, that the judgment which I have cited on covering the issue, though it is not recorded, but ultimately that has possibly recorded that my learned friend will answer whether the division bench is applicable in this case or not. A law laid down by the honorable division bench that has been recorded. Kindly see.
None of the respondents are within the original side jurisdiction.
Entertain, my lord. Otherwise, in the initial stage, I would not have, my lord.
No effective order was passed. Only a mere adjournment by 3 or 4 lines order.
My lord, they have not objected on
In some of the matters I have entertained.
Yes. I know, my lord.
Where there is a specific, there are certain.
Yes. I understand, but my learned friend.
Fully well that it is not maintainable.
Yes.
Since coordinate bench entertained the position on the original side,
my lord,
I allowed your prayer,
my lord,
and I entertained. But this is not the.
But my
not the matter under such category.
My learned friend has not
Conversion. There was similar order আগে নিয়েছে অনেকগুলো তুমি আগে যিনি ছিলেন ওটা থেকে নিয়ে নেবে
Number 3.
Coal India, even Coal India, I am entertaining.
My lord, in
though it is in New Town, I am entertaining.
My lord, this matter, my lord, earlier order was passed. If your lordships kindly see, my lord, the lordship's order and the earlier order passed by this honorable court.
My lord, this case also may be converted to appellate side.
No.
The
if your lordships kindly
MPL
see, my
has
lord,
no office at RN Mukherjee Road, 13 RN Mukherjee.
18 September 2025 order, kindly see.
They have intentionally mentioned to get the jurisdiction of the original site.
They never objected. Today, my lord, since your lordship's view, my lord, they have, my lord, seen and now they are objecting.
In previous occasion, my lord,
they could have objected.
This view is prevalent right from Justice Satyabrat Sinha.
Yes, my lord.
As his lordship then was.
Yes.
This is not my view only.
Yes. No, but earlier bench, my lord, they could have objected. They have not objected, my lord.
We have objected.
I'll see their submission, how they have objected.
It is nothing, only to get the matter heard early.
Well, kindly see Mr. Shah has.
Considering the length of list on the in the appellate side.
Well, kindly see Mr. Shah has, Ms. Shah has placed a communication and submit that the Coal India Coal Company has already communicated the petitioner as to the requirement of certain further documents, but till date no response has been received.
Just a minute. Yes, I am on this,
my lord.
On this order. Just a minute. Has already Yes, there is an order to that extent because submissions were made, communication was issued to the petitioner for submission of certain documents, and there was no response from the petitioner. That's why court passed an order. I will entertain.
My lord, only it is my duty to bring under the notice of the honorable court why they have intentionally wrongly mentioned the address. That address is not correct address. That office has been withdrawn long ago.
In an appropriate case, when the first instance court will hear this matter, court is converting those petition into an original side, from original side to appellate side. But since the coordinate bench has heard this matter to certain length, so therefore the court is not inclined to pass an order for conversion. Yes.
Now here, the father of the petitioner was an employee and he was undergone treatment and subsequently he was found unfit for duty, and my lord, his father was, my lord, terminated from the services on the medical ground. Now subsequently I have made applications, and my lord, they have, my lord, screened the petitioner, medical was conducted, and everything, my lord, has already been completed. Now after that, my lord, if your lordship kindly see page, my lord, 36, my name has also been placed. Kindly see the heading, status of employment under National Coal Wage Agreement up to January 2023.
Page 33,
Page 36, my lord.
36.
My lord. The starting page. At top, you will also will find the pending matters, and on right hand side, approved matters at top. And thereafter, you will also kindly see status of employment under National Coal Wage Agreement.
Employment on compassion ground.
Yes.
When employee died,
No, it's a medical unfitness case, my lord.
declared medically incapacitated.
Incapacitated in 2015.
You have made an application when?
Immediately. Immediately.
Now, what is the present status?
Present status, my lord, kindly see. They have displayed page 39, WD 6195.
Page 69.
39.
Yes, page 39.
39, you'll also find WD 6195.
6195.
6195. Timothy Dhani Sethi.
Sorry, my mother was incapacitated, not father. Sorry.
Mother?
Mother was incapacitated. Mother was an employee.
Mother was employed.
Yes, I have said father, not father. Then you also will find my name Shiva Sethi, son processed. So since 2015, my name is under consideration. Till date, they have not provided anything.
This process was made when?
Process was made since 2015.
My lord, we have made a communication to the petitioner in 2018. That is not on the record, but this communication was handed over to the learned advocate by the order dated 18 September 2025, that till that date no document was submitted as required by the let me finish.
What are the documents?
Now the things, as on date, till that date no documents was submitted. In the meantime, regulation has been changed, policy has been changed, and under new policy, a bi-party committee for coal industry has been set up to review and to give implementation instruction. I am giving the clause number
9.4.0.
9.4.0. 9.4.0, on clause number 9.40, a subcommittee shall be constituted which shall submit its report to the standardization committee of JB joint JB CCI 11 joint bipartite committee for coal industry till this status quo shall be maintained.
When this
my lord, till that time
was introduced,
this case,
when this scheme was introduced,
my lord,
when this scheme was introduced, new scheme,
2023.
but the husband, mother was declared physically incapacitated in 2016. Application was made in 2016. You made the delay in processing, for which you will get any leverage.
Unless the employment is completed till that time, the new policy it will come.
Already you have stated
My lord,
that it is processed.
My lord, kindly, I may be allowed to submit. In the similar situation, coordinate bench has given a order in another case, only directing the respondents to pass a reasoned order. Like that, I am not telling that I may be given to file chance to file report. We may be given to pass a reasoned order stating all the material facts in respect of their representation. Under the same reasons.
Last minute.
কপি দিন আমাকে দেখুন দেখুন আপনার কপি দেখে দিচ্ছি
দিয়ে দিচ্ছি কপি
He is making submission that the matter may be relegated to the authority for taking decision in the first instance.
So they have processed.
Because unless and until it is formally decided regarding your entitlement, court should not embark upon whether you are eligible to get the employment on compulsion ground or not.
Only one thing may kindly be recorded. If the petition is found to be eligible, but let the process.
Consequential steps shall be taken. Who is the authority to take such decision?
Only one thing may kindly be recorded. That it is a
Page 39, it was processed.
It's processed, and they have mentioned in this order the National College Agreement 11. My case is covered in 9. That may kindly be recorded.
Yes.
In this case, for the matter of HCW 9 till 11, my case is 9. You will also find from page 26 of the writ application.
Page 26.
Well, as per clause number 9.440 of NCW 9. I have been declared, my mother has been declared medically unfit under clause number 9.4.0 of NCW 9. That may kindly be reported. So,
No, it is National Coal Wages Agreement 9. No, 11.
11 in this matter, the order which has been cited. But my case is covered under National Coal Wage Agreement 9.
No, in that regard, authority has to take decision. Because if you go by the Supreme Court judgments, there are judgments two ways.
Don't mention any NCW.
Yes. That is the main issue. Whether the scheme which is prevalent at a time of death will apply or at the time of consideration. Latest judgment, last judgment of the Supreme Court headed by Justice D.C. Raj
But till there is scheme is there. My landed fund has cited.
So instead of going into this aspect, let it be decided.
Don't mention any NCW, only mention only NCW.
Issue. In 2016, he was declared medically unfit. 15. Where is the order relating to or the report of the medical board?
Medical board report, they included, will also will find, my lord, page 27. Dhani City, General Mazdoor, Sadhana area hereby terminated from services with effect from 14th October 2025 under voluntary retirement on medical.
Matter is heard in presence of the learned advocates representing the petitioner and Eastern Coalfields Limited, within bracket for short ECL, close bracket, next bracket. Mother of the petitioner was employee under ECL. Who was declared medically unfit. And was permitted to retire voluntarily on 14th October 2015. Stop. In this regard, an office order was issued by the concerned authority of ECL on 13/14th October 2020. Stop. Page 27, what is the date? 14th October 2015. 2015, 2029, 2015, stop. Petitioner, being the son of the aforesaid employee of ECL, by presenting this writ petition has claimed direction or has prayed for direction upon the concerned authority of ECL for providing appointment on compassionate ground. Stop. Next paragraph. It is brought to the notice of this court in reference to a document at page 39 of the writ petition that application of the petitioner for appointment on compassionate ground was duly processed by the concerned authority, and it is alleged that thereafter no steps were taken to appoint the petitioner on compassionate ground. Next paragraph. Learned advocate representing ECL submits that there is introduction of new scheme requiring compliance of formalities under the said scheme relating to appointment on compassionate ground, for which would make the petitioner eligible to be appointed accordingly. Next paragraph. Though application was made long back, just after permitting the petitioner to retire voluntarily, since petitioner was declared medically incapacitated, but till date no decision is taken by the concerned authority of ECL on the claim of the petitioner seeking appointment on compassionate ground. Next paragraph. Next, this court finds, this court finds no purpose would be subserved in keeping this writ petition pending. Stop. Who will decide?
Respondent number 7, the agent.
No.
Director Personal is the highest authority.
Director personnel ECL. Director personnel within bracket ECL, being respondent number 3, is directed to decide the claim of the petitioner seeking appointment on compassionate ground by 8 weeks from the date of communication of this order, and said respondent number 3 shall pass a reasoned order after granting opportunity of hearing to the petitioner or his representative. Stop. The decision to be taken by the respondent number 3 shall be communicated to the petitioner by fortnight thereafter. Next paragraph. If respondent number 3 decides that petitioner is eligible to be appointed on compassionate ground, consequential steps shall be taken to complete the formalities prior to appointment of the petitioner. Disposal bole sir, writ petition is disposed of. Writ petition is disposed of. Urgent xerox certificate.
My lord, instead of deciding the issue by the director personnel, any other officer authorized by
He is the appropriate authority. Sorry.
Item number 4.
May I file my exception?
Your Lordship, there was a direction for me to file affidavit. The affidavit was made ready and the same was served upon them, but inadvertently the entire original file from the court has been misplaced, Your Lordship. So I need to reaffirm the affidavit, Your Lordship.
Previously affidavit was affirmed and filed.
It was affirmed, my learned senior was served with the affidavit.
So the question of reaffirmation does not.
Your Lordship, but the original file is.
It was not filed in the department.
No, it was
file
not.
an affidavit.
Your Lordship.
Yes.
The exception can be only taken once my affidavit comes on record, Your Lordship.
Oh, that affidavit copy is with.
Your Lordship, the original.
File it. Yes. Exception is filed on behalf of the petitioner and same is taken on record. Next paragraph. Ms. Pandey, learned advocate representing ECL.
Your Lordship, all the respondents.
Has submitted that a reply which was affirmed on behalf of ECL is lost and prayer is made to grant leave for reaffirming the affidavit prior to filing of reply. Stop. Next paragraph. Leave is granted for reaffirming the affidavit in connection with reply by 24th of 24th December 2025, and same shall be filed by 7 days after the ensuing Christmas vacation. Stop. List the matter under the heading hearing in the monthly combined list of Acha, list the matter under the same heading for further consideration. On 21st January 2026.
Your Lordship, there are no admitted dues. Sincerely obliged.
Item number 5.
My lord, in similar situation, this case,
Something different if it is cancelled also last order.
I have got the written instruction. The instruction to the.
Okay, my lord, they submitted on the last day. My lord, that petitioner has crossed the age limit of 35 years. No, they have submitted, there is a discrepancy between the two documents, that is service record as well as the matriculation certificate. That's why they cannot process the employment. The lordships observe, my lord, kindly see that if there is any dispute between the two records, then the matriculation certificate will prevail. Now, if your lordship kindly consider that even in a matriculation certificate, yes, my lord.
দিতে হবে না এটা আমরা প্লেস করছি it is the instruction for same reasons it is My lord, in this case, though we submitted on the last occasion that there is contradiction about age, and your lordship my lord, at present, that we will solve regarding age, but constraints is coming only for that bi-party committee has to give clearance for method. He is also falling under the same head. That is, we have got written instruction. A similar type of order may kindly be. Marriott, I have got oral instruction that regarding age that will be decided in due course as observed by the Honorable Court.